So are we ready to resume? So we are ready to resume, and we now give the floor to the respondent for the respondent's opening.
Thank you, Mr. President. And I just confirm that we have sent the PDF version of the opening slides, and we also have paper versions that have been or will be distributed as we speak. I have the honor to represent the Republic of Colombia in this case. I will share the opening presentation first with the director of ANGE, Mr. Camilo Gomez Alzate, who will say a few words. Then my partner, Ms. Jimena Herrera Bernal, will address the tribunal on the factual context of this dispute. And then I will pick it up, perhaps after a break, addressing this tribunal on jurisdiction and merits issues, and Ms. Yael Ripo-Gorman will finish the respondent's opening. So without further ado, I now pass on to the director of ANGE. Thank you.
Buenas tardes, señor presidente, señores árbitros, señores colegas de la contraparte, señores representantes del Departamento de Estado de los Estados Unidos y a todos los demás presentes en la audiencia. Yo soy Camilo Gómez y soy el director de la Agencia Nacional de Defensa Jurídica del Estado colombiano. El día de hoy nos convoca un arbitraje muy particular y de especial importancia para el Estado. Colombia es reconocida en muchos laudos por el cumplimiento del debido proceso y de sus obligaciones internacionales. Las actuaciones que los demandantes consideran violatorias del Tratado de Libre Comercio entre Colombia y Estados Unidos responden a la actividad regulatoria legítima del Estado, con base en la figura de la extinción de dominio, reconocida como una de las principales herramientas en la lucha contra el narcotráfico y la corrupción en el mundo. La ley de extinción de dominio consagra una acción de carácter constitucional, imprescriptible e independiente del proceso penal y bajo ninguna circunstancia puede confundirse con un mecanismo de expropiación. Colombia, señores árbitros, ha sido y es aún la mayor víctima del problema mundial de las drogas, y eso nos ha obligado a desarrollar avanzados sistemas legales para combatirlos. Los narcotraficantes han asesinado jueces, fiscales, periodistas, civiles inocentes, han explotado aviones y centros comerciales, y también, lamentablemente, han penetrado el sistema de negocios en Colombia y han encontrado a personas que prefieren aceptar estos negocios, así estén manchados con el dinero maldito del narcotráfico. Hoy Colombia sufre la desgracia de producir el 70% de la cocaína del mundo, que equivale a 1 billón de dosis de cocaína pura. De cada 1000 gramos de cocaína pura, se llegan a producir 9000 dosis de cocaína comercial, cuyo precio por dosis puede llegar a más de $200 en ciertas zonas de los Estados Unidos. Los expertos, incluso de Naciones Unidas, hablan de un precio promedio de más de $50 por dosis comercial. Todos estos miles de billones de dólares del negocio del narcotráfico no se mueven en cajas ni en maletas de dinero en efectivo, sino por medio de sistemas de lavado de activos de la mayor sofisticación posible. El problema del narcotráfico en Colombia, y especialmente en la zona de Medellín y Envigado, ha sido conocido públicamente en el mundo. Hasta películas y series de fama mundial existen. Por este público conocimiento es que los inversionistas extranjeros, cuando invierten en Colombia, no pueden desconocer este fenómeno ni sus alcances. Tienen la obligación de conocer a fondo las reglas de juego, especialmente en materia de extinción de dominio, y deben ser muy conscientes de su aplicación. Esto exige especial diligencia y la mayor prudencia por parte del inversionista. La diligencia, señores árbitros, de un inversionista no puede ser la misma cuando se compra un predio en Washington que cuando se compra en Medellín o Envigado. La extinción de dominio ha sido y sigue siendo una de las armas más importantes para hacer frente a una de las principales modalidades delictivas como la que se observa en este caso. Se trata de la estructuración de complejos negocios fiduciarios que han permitido que grandes extensiones de tierra de origen ilícito pasen desapercibidas y entren al tráfico económico normal. En este caso, el proceso de extinción de dominio inicia tras conocerse que en la cadena de tradición del lote denominado Proyecto Meritage se encontraba el señor Iván López, un narcotraficante reconocido que ya había sido extraditado a los Estados Unidos. Una empresa criminal armada que asesina, extorsiona, sobre todo lava dinero y trafica drogas, y que por décadas ha afectado los intereses de los colombianos. En el caso que nos reúne hoy, los demandantes se fundan en el supuesto inicio corrupto y arbitrario del proceso de extinción de dominio por parte de la Fiscalía General de la Nación. Yo quiero, con total firmeza, a nombre de la República de Colombia, rechazar de manera enfática las afirmaciones que han presentado los demandantes en relación con las actuaciones de nuestras autoridades judiciales. Por el contrario, nuestros jueces y fiscales diariamente ponen en riesgo su vida y la de sus familias por luchar contra el narcotráfico y el lavado de activos. Ellos son el blanco de los intereses criminales, pues son los que, a nombre de todos nosotros, defienden la legalidad y la justicia. A ellos los admiramos, los respetamos y los apoyamos. No solo nosotros en Colombia, también las autoridades de todos los estados comprometidos en la lucha contra el narcotráfico. Según lo veremos a lo largo de esta semana, el caso de los demandantes se caracteriza por una muy cuestionable paradoja. Entre más grave la acusación contra el Estado, más débil la prueba que la soporta. La teoría de los demandantes sobre los motivos que llevaron al Estado colombiano a extinguir el dominio es inverosímil. Yo pregunto, señores árbitros, ¿qué sentido tendría que un narcotraficante corrompa a un fiscal para iniciar un proceso de extinción de dominio que solo puede concluir con que el Estado sea el que se convierta en el titular del terreno que ese narcotraficante supuestamente quería recuperar? Este tribunal tiene ante sí un paradigmático ejemplo del uso indebido del arbitraje de inversión. En primer lugar, los demandantes comparecen a esta audiencia sin prueba clara sobre una inversión significativa de capital extranjero. En segundo lugar, los demandantes cuestionan la legalidad de una medida que ni siquiera había madurado en el foro doméstico para la fecha de la presentación de la demanda arbitral. Una reciente decisión del tribunal le permitirá a Newport demostrar en un juicio si en realidad es un tercero de buena fe exenta de culpa. En tercer lugar, los demandantes elevaron ante ustedes cargos de corrupción de alcance sistemático, sin esperar siquiera a que los hechos denunciados fueran investigados en Colombia. Por esta actuación prematura, el expediente arbitral está lleno de decisiones sobrevinientes en donde fiscales y jueces independientes han coincidido en que no existe un ápice de prueba de corrupción en el caso Meritage. Los colombianos hemos padecido muchos males derivados del narcotráfico y la criminalidad organizada, por lo que no sería justo que también tuviéramos que asumir una condena internacional billonaria por cuenta de la legítima aplicación de la figura de la extinción de dominio sobre un bien de probado origen ilícito. Este proceso busca poner en duda uno de los más valiosos instrumentos en la lucha contra el narcotráfico. A esos criminales, señores árbitros, no les duele ni la muerte ni la cárcel, les duele perder el dinero que la extinción de dominio les quita. Con su venia, le doy la palabra a las señoras Jazz, Banifatemi y Jiménez Herrera, quienes continuarán con el alegato del Estado colombiano.
Thank you. Gracias.
Mr. President, members of the tribunal, you have heard the director speaking about the importance of this case, and you have heard him referring to the Oficina Envigado. In fact, you have heard several times the mention to the Oficina Envigado. What's the Oficina Envigado? The Oficina Envigado is an armed criminal group that was born in the 80s as a branch of the infamous Cartel de Medellín directed by Pablo Escobar. What was the function of the Oficina Envigado? The function of the Oficina Envigado at its beginning, and it still continued to be, to control drug trafficking, but also, and importantly for this case, was in charge of collecting the debts of an asset on behalf of the Cartel of Medellín. And when I say collecting the assets of debt, I'm not referring to going and kindly asking through a letter to have some debt paid, but forcibly making people give up assets and extort people and extort money. In the 90s, the Oficina Envigado merged and was instrumental in the creation of the paramilitary groups in Colombia. Paramilitary groups that fought the guerrilla, but also that were involved, same as the guerrilla, in drug dealing activities. One hallmark of the paramilitary actions in Colombia has been dispossess forcefully many people in Colombia of their lands. In fact, if you were to look at statistics, back particularly when they were particularly active, the paramilitaries in the 90s and in the 2000s, you will see that the number of refugees in Colombia, internal refugees, were just below Congo. Now, the Oficina Envigado has continued operating and operates up to the date in Medellín, obviously in the area of Antioquia, but has morphed into a transnational criminal organization that is present in Europe, has links with Hezbollah, and is linked with the Cartel de Sinaloa and the Cartel. As the director was saying, how is the only way that criminality can be effectively combated? And that is targeting the gains. And that's the whole point of dealing with money laundering and trying to target the gains to stop the incentive for criminality. In fact, asset forfeiture proceedings and the Colombian asset forfeiture proceedings had been internationally recognized as an effective tool to fight criminal activities and to deprive criminal enterprises of their illicit assets. Here you have that recognition by the GAFILAT, which is a financial action task force in Latin America that surveys and tries to prevent and combat money laundering. Now, you have heard a lot about the asset forfeiture proceedings in Colombia. You will have later on in the week to hear from the experts. We will hear from Mr. Reyes, and you will also have two of the prosecutors that are day in, day out dealing with this kind of procedures and can tell you what are the phases and how they really operate. in any event, I think that it's important so that the tribunal has a more clear idea of how this operates to describe the asset forfeiture proceedings in a general way. One important thing is asset forfeiture proceedings do not follow the individuals. And this is important because you have heard the other party saying what Colombia should have done is follow the people that received the assets, the money from the sales. Doesn't follow the people. It follows the asset tainted for its illicit origin. What's the purpose? To forfeit the assets that are either the proceeds of crime or destined to criminal conduct. This procedure has two stages. An initial stage that is carried by the prosecutors at the Attorney General Office by the unit of asset forfeiture. And then it has a second stage, this is a trial stage, where the parties in this trial stage are going to be the prosecutors that are presenting the request to the courts to forfeit the assets, and obviously the parties that are claiming that they are affected parties, that they are bona fide, and the final decision on whether these parties are really or not third parties on good faith without fault third parties, it's only taken at the end by the courts. And I will go about that in a moment and explain how everything evolves. One important point here is you will have here opposing parties saying that there are not controls. That's not true. There are controls of legality in place, and that contrary to what you have heard, include both formal and material control. That's the case of the precautionary measures that were taken in this case. The procedures, adversarial procedures at the judicial phase, due process of law is observed, and they are decided by an independent judge. The decisions can be appealed as if they have indeed been appealed in this case. Another point that is important, these are not procedures that are criminal in nature, they are civil. So they are not charging the person because there's a criminal conduct. They are charging the asset, doesn't matter who has it at that moment, because of the origin of the asset. Now, you have heard a lot about the claimants not having been considered bona fide, etc. That's not true, and I will go into what is at what stages and what is at each stage either the prosecutor or the court have to decide and find in this regard. Last thing that was mentioned by the director, but it's important to bear in mind, is the asset forfeiture proceedings are not subject to a statute of limitations. And that's quite important because the due diligence that an investor needs to conduct is dictated and has to be done bearing that in mind. Very briefly, I want to refer to some typologies of money laundering that had been identified by the Colombian Superintendency of Notaries and Register, that has its own judicial police division, in the real estate sector. The real estate sector in Colombia has been considered, and it's considered to be a high-risk sector for money laundering. There are several typologies that fit what happened in this case, but I want to walk you through a couple of them. So usually you have an owner of a property who's a drug dealer or a familiar of the family, part of the family of drug dealing. What happens? If that person, the drug dealer, gets killed or that person is extradited, immediately the other drug traffickers take control of those assets. They dispossess the families, they forcefully make them to transfer the land to them, and it remains within the EUIEF, which is the Colombian Financial Intelligence Agency, has detected a series of red flags of money laundering. What are those? Operations that are performed between people that have an unequal economic purchase power. Successive sales of the same asset within a very short time frame, signs that the supposed buyer or seller is not the material owner of the land, signs that the person is not acting on his or her volition, and that the true interest of the interested party is concealed. Natural persons that pay in cash, and that's millions, on behalf of a client, and unfortunately the use of trust structures. You heard the claimants refer to the commencement of the asset forfeiture proceedings, in this case, as if they have come out of the blue, and if they were the result of the volition of a sole prosecutor who had decided, I'm going to target this asset. Nothing can be far from the truth. So, on 3rd July 2014, Mr. Lopez Vanegas, whom we know that through Sierra Alta Lopez and Compañía had bought in 1994 this plot of land, of part of which is now the Meritage lot, appeared and who had been extradited to the US, files a complaint before the Attorney General office, this before the prosecutor that is specialized, that's prosecutor 24. Attention, is not that the prosecutor 44, that is Ms. Ardila, 24 that specialized on the Oficina de Envigado. And he alleged that he has been forcefully dispossessed of the land where the Meritage plot is being built. Prosecutor 24 hears and takes the declaration of Mr. Vanegas and asks him, why is it that you're just denouncing this? And he says, and this is a fact that the specialists in Oficina de Envigado know, because it's only now that the people that have been involved in this forceful transfer are either dead or have been extradited. So he felt at that point he could claim. Whether the question is if of the story about the kidnapping, I will go back to that. That's not the question. The question is, this person appears and claims that the land is his. The prosecutor 24 sends the investigations, and you won't see that here, but sends the investigations to asset forfeiture, but asset forfeiture that were being carried out in regard of the assets of Mr. Héctor Santamaría Restrepo, a.k.a. Perra Loca. Later on, you will see that the process of Mr. in respect of the Meritage and the one of Mr. Héctor Restrepo Perra Loca were divided. But one important thing here is, you heard this morning the claimant saying there was absolutely no sign of Iván López Vanegas in the title. You will see, and you have before you, the deed of 1994, where Sierra Alta López, pursuant to which Sierra Alta López acquired the plot of land, and you will see Mr. López Vanegas' signature as the representative of Sierra Alta López. Why? You will say, they say that it didn't appear, and I will go back to that later on the due diligence, because the due diligence was patently insufficient. The due diligence was limited to 10 years, and please remember, I said the statute of limitations in Colombia is not subject, the asset forfeiture action is not subject to a statute of limitations. So if you see here, we have one of the red flags, assets that are linked directly or indirectly to criminal groups, in this case, the Oficina de Envigado. What happens? Again, the claimants will tell you that this was Ms. Ardila coming out of the blue without any more information and just saying there has been a kidnapping, which then they allege was demonstrated that didn't exist, and I'm gonna initiate asset forfeiture proceedings. No. Before that, they have been the judicial police of the Superintendency of Notaries and Register went and studied 27 records of real property, went to 19 notary offices in Medellin and reviewed 52 deeds regarding or in connection to the Meritage lot. Having completed this exhaustive investigation, the judicial police found out that there were serious irregularities in the deeds, including signatures that seemed forged. That was the case of the one of Sebastián López Vanegas, the son of Iván López Vanegas. Alterations in the deed, lack of properly given attorney powers, the errors in the date, points at which the attorney that was appearing on behalf of the buyer and seller, and also grantors that appear as unofficial representatives of the parties. What was the hypothesis that the judicial police of the superintendency understood was happening in this case? Say, there has been a criminal organization that has been have been trying to get property rights, valuable real property, located in strategic areas of Medellin and Antioquia, have resorted to a pattern of extorting, kidnapping, coercing, that's forcefully making the owners, or the people that appear as owners, transfer the properties and falsifying the signatures. And they have been using front men to give the appearance of legality. And this is consistent with the crime of money laundering. So you see here, second check, persons are not acting of their own volition, identity of the people behind these transactions is concealed. We come to 22 July 2016, and here, before that, on 5th, that's the resolution of 22 July 2016. You have seen today the claimants dismiss it and say, well, if you look at the way the precautionary measures were imposed, they came in August, they come out of the blue, and they didn't give this resolution. Now they're saying they have a resolution before. Well, that's how it works. There was a resolution, and the measure to impose precautionary measures on the Meritage lot, and then on August 3, they were imposed. Now, why were they imposed? And why was it that the claimants weren't called to say anything before they were imposed? Because when they're imposed, it has to be, obviously, there's no previous notice that they are going to be imposed. That's the whole point of the precautionary measures. And why? Why did they consider it necessary and urgent? Because this lot of land, there was a project that was being built. There were units that being sold to purchasers. The whole structure was, what was going on was subdividing, and there were units that were being paid by people who will be in bona fide being sold this. So wonder why it was necessary and urgent. You will have heard the claimant saying, well, no, what the Fiscalia, the Attorney General Office should have done was attach the fiduciary rights. That's not how it works. What's the asset that is tainted? It's the lot. By law, it's the lot that needs to be attached. Further, imagine if they have gone and attached the fiduciary duties, the building will have, the construction will have continue, and then what? And then they will have to reverse everything, and when it's finished, say, well, now you will have to be, you have not an opportunity to allege that you didn't have before. I mean, it just doesn't make sense. It's the property lot that has to be attached. It's not the gains of the people that have been transferring, and it's not the fiduciary lot, rights. Now, Ms. Ardila, who you have heard mentioning several times here, she didn't stop here. She continued with what she should do under the law. And the law, what the law requires, is for the prosecutor to collect sufficient evidence to reasonably infer that there's absence of good faith. There's no requirement at that stage in the proceedings that she proves that they are good or bad faith. In fact, that's not in her remit. That determination is not in her remit. What she has to do is say, I have collected sufficient evidence and I can infer there's no good faith of the third-party holders. But in any event, what does she do? She starts investigating further, and she calls to the several people in the chain of title to speak and to interrogate them about how this transfer happened. The first one is Mr. José Varela Arboleda, who appears as the purchaser, first purchaser from Sebastián López Betancourt for the Meritage plot, and demonstrates that he doesn't have the means. He's a fruit street vendor. Mr. Arboleda further states that he was forcefully taken to the notary and made sign some papers and was told to shut up, not to say anything to prosecutors, to keep it quiet. She then, Ms. Ardila, interviewed Mr. Cardona, who had purchased the land from Mr. Arboleda, who says, I made no payments. Though I appear as the title holder, I made no payments for the land. One more, she goes to Ms. Tatiana Hill, who also appears in the chain of title, and she says, it was my partner, Guru, whom you have heard mention before, who actually had the property, and my name was just put there basically, but I didn't have the money and I didn't put the money. Marks, we have again insufficient economic power and people acting as frontmen. Thereafter, in her investigations, Ms. Polo, again, speaking with one of the frontmen, in this case, frontwoman, Tatiana Hill, hears that, in fact, it was Perraloca at the end who bought from Tatiana Hill and Guru the property and paid in cash. Once again, hallmark of money laundering. And we come to the other big hallmark and red flag, and it's the division and subdivision and then reintegration of properties that we can see with the Meritage lot. I want to stop here a moment because the other party has told you how come that Colombia has gone and has forfeited, or it's in the process of forfeiting because it has not yet, or we'll see if that happens, the Meritage lot, but they have not pursued the other plot of land. So we're taking here with minor alterations, the image that the claimants show you before, and you will see that at the beginning of the chain, you have two companies, Sierra Alta López Compañía, and you will have Entre Lagos Orozco Vanegas Compañía, which the two of them acquired in 1994 land, and you see the big lot there. One had 75% of interest, the other had 25% of interest. If you continue on the line, you will see that there are several subdivisions back and forth, property consolidates, and yes, the properties go through the same frontmen, but at one point they divide, and you will see lot A1, lot B, and this is 2006 and 2006, sorry, and lot A. The Meritage project is being built in what will be lot A and lot B. Lot A2, however, which is why they refer as it's the neighboring property, they are saying why Colombia didn't pursue it. That's not correct. One important thing, this lot, it's combined of assets that are, or money that is tainted with drug dealing and money that is not. So far, there's no evidence that Entre Lagos Orozco Vanegas, who was owned by the half-brother of Mr. Lopez Vanegas, was involved in illicit doing.
I'm sorry, this is too quick. I don't understand that. Because, I mean, if the lots were divided in 2006 into Lot A1 and Lot B, these are the two lots that became the ground for the meritage, and to Lot A2, the claimant was saying the problem was the same. I mean, if you go down the chain of property, and you start with 94, as you told us, wouldn't that be the same for that lot? That was their argument.
Except that it was more.
And to add to the President's question, if I may, I understood you, but I may have misunderstood. I understood you to say that Lot A2 was actually put under attachment as well, or was it not?
No, no. So on the first point, Lot A was partly, so if you go at the beginning of the chain, you have 25 interests of Entre Lagos Lopez Vanegas. Nobody has said that there is that money comes from an illicit force. Then it's all combined. Then you go out to Cardona, where you see there where they again.
I'm sorry, but even though that Mr. Lopez Vanegas was the legal representative.
But of Sierra Alta.
Yes.
Not of Entre Lagos Vanegas.
But that was Jaime Vanegas, the half brother.
Their half brother.
Yes.
Correct.
Okay. So, but he's not suspicious or what?
There has been no information or any kind of suspicion of drug trafficking or illicit activities by Mr. Vanegas, the half brother, Jaime Vanegas Orozco.
Okay, but that ultimately is it relevant? Because I mean,
It is.
Because in 2000, when the lots were merged again into one.
That's correct.
Lot. So
that is
then-
correct. Yeah, that's correct. And then they are divided.
Yes.
The problem is that there's a percentage that it has no illicit origin. So when you see Lot A after we divide, yeah, part is tainted because it came from part of the Sierra Alta plot, but part is not. So what happened at that point is Miss Ardila opened another investigation and said, please investigate. And
I'm sorry. I haven't understood. Please start again from the division of Lot A, with the 25% going to Cardona and the 75% going to Luis Jose Varela Arboleda, and explain why this is relevant to what happens next.
what is relevant here is that although these lots are combined on Cardona, you have part of that money that goes to that lot, 75% that is from illicit origin, 25% that is not.
Why is it from illicit origin?
The one of Sierra Alta Lopez is illicit origin, the one of Vanegas is not.
Because it was only the half brother.
No, because there's no record of him being involved in trafficking activities.
Please proceed.
Then you go to Cardona and you see that it's subdivided again, right? In different plots. Lot A1, Lot B, Lot A2.
Yes.
And I'm sorry, since we are stopped anyway.
We're sorry for that.
Yeah. I understand the point that A2 was not attached because, as opposed to A1 and B, it was not being parceled out to acquirers. That's what you're saying as of August 2016, right? What happens after that with A2?
it wasn't attached.
Why not?
Later
If it
on.
is, I mean, if the origin is just as dubious as the other one, why is it, or how come is it that one is attached and the other one never gets to be attached? I can understand the point if there is urgency, but the urgency hasn't lasted from 2016 to 2022, right? Understand that it's complicated, and we all know, there are some people in this room who do have some experience with money laundering matters, and we know how difficult it can be. But still, if you have a drawing that shows essentially that the origin is the same, so the funds at the source are the same, why is it that one part of the proceeds of this money laundering, if it is, ends up never being attached? How do you justify that? I'm sure there is an explanation.
So I continue here about the transformations of plot of land and subdivisions. That is another hallmark. And we arrived then at the provisional determination of claim.
I'm so sorry for the interruption. The interpreters are asking me if you could speak a little bit closer to the microphone.
Okay. We arrive to what is called the provisional determination of claim, which is one of the stages in the initial state before the prosecutors. And here I would like to stop again and make clear that, contrary to what the claimants had said to you, it is not true that Newport was not allowed to intervene. Once there had been the provisional measure, the parties that had been affected by the measure, and I'm using affected here in an ample way, that's the term, were notified of these proceedings. You will also have heard that Ms. Ardila acted contrary to the law and due process because, allegedly, she did not give the copy of the resolution of the provisional measures to Corfi Colombiana. The way it works under Colombian law is the title holder, which at that point was Corfi Colombiana, has to go to the Attorney General office to get notified. When the lawyer of Corfi Colombiana, Mr. Cintura, who you heard speaking of this morning, arrived, she was not present. He had contacts in the Fiscalia, he went around and had another prosecutor tell the assistant of Ms. Ardila to give the copy. That's what generated the incident that you have heard that the assistant was sanctioned, etc. Simply, it wasn't within her remit to give the copies if the prosecutor of this case wasn't there. Now, provisional determination. Prior to the provisional determination, Newport had been notified. In fact, it had presented 3 documents of petitions in which they claim to be bona fide buyers. It is not the obligation, and it's not what the prosecutor has to say, to determine and make a statement in the provisional determination as to whether they are or not bona fide buyers. It receives, it observes. If it continues to believe there are reasonable grounds to infer that it's absent of good faith, the prosecutor continues the process. So the prosecutor, Ms. Ardila, issued the provisional determination of claim on 3 grounds. The grounds were that the lot was direct or indirect the product of an illicit activity, that it has suffered a series of total or partial transformation or conversions, and that to put it that way, the illicit activities, and that there has been an increase in the assets of the owner at the beginning that can only be explained for illicit activities. These were the basis on which Ms. Ardila started the proceedings, and having notified Newport, having included them as affected parties, the proceedings continue. You have heard the claimant say that Newport had been denied due process, and that's not true. They have had multiple opportunities to present their claims. As I was saying before, there are two phases in this proceeding. The initial proceeding, the initial phase or stage, before the prosecutors. During that period, the claimants were notified and were included as afectados. And they presented, in fact, several petitions. In fact, if you look at the, if you look and moving, I'm going to move quickly to the order of the requerimiento. You see here in the little square that Mr. Caro, which is the prosecutor that took the case, that was reassigned to the case after Ms. Ardila, includes Sociedad Newport as afectados. So it is not true that they have not had an opportunity to participate and they were excluded from the exception of these proceedings from the process. Now, another point that it's important here is it's not true that there has been no controls of the actions or the decisions of Ms. Ardila. Once again, you heard that Ms. Ardila just took the decisions discretionarily and run with them. No, Ms. Ardila, as regards the measures taken by Ms. Ardila regarding the precautionary measures, were controlled by the courts. Corfi Colombiana, which is the one that has the title, requested the legality control to the courts. And again, they are formal and material. They are not just formal. And again, unsatisfied with that decision, Corfi Colombiana appealed the decision of the judge of control, and the first specialized asset forfeiture, the tribunal, sorry, not only the specialized asset forfeiture judge, but also the tribunal, both stated that there has been no violation of due process, and that the prosecutor has gathered persuasive elements of proof which make it possible to establish illegal activities based on which it concluded that it was necessary and urgent to order the precautionary measures. And furthermore, they were needed to avoid ongoing trade or transfer of the property to third parties. The Tribunal of Bogota, which was the second instance, also find that there had been sufficient evidence to impose a precautionary measure, and importantly, noted that the appellant, Corfi Colombiana, was getting ahead the debate because Corfi Colombiana, as the claimants have done on Newport, insisted on being recognized as the bona fide, without fault, third party. As I have said, that's a determination for the judge, not for the prosecutors. You have heard now of what happened in the phase of the, on the trial phase of these proceedings. So, once the prosecutors present the case to the courts, and the last of the acts in that chain is what is called the requerimiento, or request for the asset forfeiture. And at that point, you have the two adversarial parties, or several, in the trial stage. So when the judge of the Second Circuit of Medellin obtained or received the request from the prosecutors, it accepted it 3 times. It rejected it for formal reasons, but then it accepted it and then analyzed who are the affected parties that are going to receive in this trial phase. And what was the logic and the decision of the judge? So the judge looked at the law. This is the law 1708 of 2014, and his interpretation was, under Article 30 of the law 1708-2014, we see that for those cases where what is being attached is movable or immovable property, the affected party has to have rights in rem. If it has personal rights, if it has contractual, other kind of contractual rights, that's not enough. It's not rights in rem. So the second district, judge of the second district in Medellin based its decision on this. Who had title at that point? Corfi Colombiana de Trustor. Who was who appeared as the title holder in the deeds in the register? Corfi Colombiana as the Trustor. So you can agree or not agree with the decision of the judge of first instance, the second district of Medellin, but his interpretation was based on law, and he spent multiple, it's a very long and recent decision. So
Does that
yes.
Does that mean that, for instance, if one plot was about to be sold, actually it had already been sold to an acquirer, but title had not yet been transferred, or if there was a plot of land that was being financed by a bank, they would not be entitled to intervene under the law, because obviously they would have no rights in rem, right? They would have only personal title.
In a strict interpretation of the law that apply, yes. That's why afterwards, on appeal, the tribunal, Superior Tribunal of Bogota, gave another view and said, I'm giving an extensive and open and guaranteeing interpretation, and I'm going to allow Newport, who has signed a sales purchase.
2022 decision,
That's correct.
which unfortunately comes 6 years after the attachment, right?
In that period, correct, but in that period, there's just the appeals. At no point is that Newport cannot intervene. In fact, there are continuous appeal and Corfi Colombiana too. And yeah, it comes 5 years later. I'm going to stop for one moment in what's the concept of bona fide without fault in Colombia. And this is not just bona fide general, it's a it requires a high threshold of due diligence. So it requires an extensive and exhaustive analysis of the title, and in particular, when you're buying in an area that you know, and it's known to be a place where there has been violence, drug trafficking, and dispossession of lands. We're going to look at the due diligence on which the claimants rely. They rely on a title study by Otero and Palacios that was commissioned by Royal Property Group. That study was wholly insufficient. It covered 10 years, and as a result of that limited analysis, you will see the request for information that then, based on that study, Corfi Colombiana presented to the Asset Forfeiture unit was also incomplete. Had Otero Palacios conducted a full investigation, they will see, as we have seen before, and contrary to what the claimants say, that indeed there was Ivan Lopez Vanegas appear as the representative of Sierra Alta and was indeed, if had they just done a Google search, they would have seen that he's a drug dealer. I go now to the wrongly called certificate of clean title. The Attorney General Office responds
Sorry,
to...
just to make
Yes.
sure I understand it, I apologize for
No.
the repeated interruptions. Your point is that finding Ivan Lopez Vanegas as a signatory on the deed was sufficient to make the purchaser, that is Mr. Seda, to put him in a situation where he should have suspected an unclean origin of what he was being
That's
buying.
correct.
That's the point you make.
That's the point, yes. The claimants rely on the two requests or petition rights that were presented by the claimants and Corfi Colombiana to the Attorney General's office as regards whether there were criminal proceedings in connection with a series of people that appear in the deeds. Problem is that the list of people here did not include Sierra Alta, Lopez and Compañía, and Ivan Lopez. Why didn't it include it? Because it didn't go back more than 10 years. And they didn't look that the company, this company that appears as Inversiones Nuevas now, had changed its name, and that was in the deeds to had changed its name from Sierra Alta Lopez and Compañía, and whose representative was Ivan Lopez Vanegas. But the other point is, it is not for the Fiscalía to conduct the due diligence, and there's no certification of clean title. The wording on the responses to the rights of petition of the Fiscalía are very clear. They say, in the information that we have, this unit, they can be other units investigated. As of today, we don't find these names. The claimants have told you that now the wording of these responses had changed. Yes, it had changed because of the abuse. It had changed, but not significantly in the terms that it was circumscribed. It was clear just what we have at this moment, the information we have, and remember, asset forfeiture proceedings don't have a statute of limitations.
But it is somewhat reassuring to know that a list of people are not on the AG's, on the Attorney General's hunt list, right? It is reassuring.
Now, you were asking about the obligations of Newport. Yeah, Newport had a high level, a high threshold of obligation of checking with whom they're dealing and to try to comply with the rules, which it didn't follow. And you could hear more of this, you will be able to hear more of this when you also hear of the analysis of the obligations of the buyer from Dr. Reyes. One point that is an absolute breaking point in this proceeding is Mr. Seda, by his own admission, says that Lopez Vanegas contacted him in early 2014, claiming to be the owner of the Meritage lot. Mr. Seda says that he asked one of his lawyers, Juan Pablo Lopera, to check who Mr. Lopez Vanegas was. And the response was, he's a drug dealer. What did Mr. Seda did? Nothing. He said he went to Corfi Colombiana. He says he went to La Palma. We know now who La Palma is on. They say, oh, don't worry. Frankly, if you know that there's a drug dealer that is claiming property here, you go back to La Fiscalía. He will say, the Attorney General, he will say, oh no, I didn't trust them. That doesn't excuse it. You know that there could be an asset forfeiture, and you know it for a fact. In case there was any doubt that he didn't know before, and assuming, which is not the case, that it was difficult to find before, because in a Google search it would have come out, he knew in 2014. 2014, no construction of the Meritage project had been started. The contracts could have been rescinded, terminated, and save all this pain. I go back again to one point that it's important, and sorry to belabor it, but it's quite important to understand that it is not for the prosecutors to determine who is a bona fide without own third parties. Final determination, it's the courts. The burden on the prosecutors is to gather enough evidence to infer that may not be bona fide in the persons that are claiming to be the buyers, because there has been insufficient due diligence. You would have seen the claimants in their reply heralding the decision of the Colombian Constitutional Court C-327 and saying, you see, the Constitutional Court now recognizes that our level of due diligence was not a high threshold, except that this decision doesn't deal with assets of illicit origin, but licit origin. Again, Dr. Reyes could explain much more in detail this point, and I'm sure the experts will explain. The Constitutional Court does not pronounce itself on things that have been res judicata, which is what it's required in terms of due diligence when you're dealing with assets of illicit origin. I'm gonna move to the meetings that were recorded by Mr. Seda with the members of the with the Fiscalia.
Before you move to
Yes.
that, allow me one hopefully final interruption. Do I understand the respondent's case as being that with a properly due diligence, all sorts of alarm bells should have rung, because it was clear that this was at the origin and at a later stage tainted with very dubious people and very dubious money? Is that the position?
The position is the origin should have been made clear.
I understand that, but go one step further. Is the respondent saying that the dubious origin, the polluted origin, and the presence of dubious characters in the background would have been made evident by a reasonably well-performed due diligence, and that to this day it is clear that there are dubious people involved? Is that what the respondent is saying?
The position is that due diligence will have revealed Lopez Vanegas at the origin, and a simple due diligence with Google, who was a drug dealer. More difficult perhaps to see the other transfers, yes. But Lopez Vanegas would have been found at the origin and being a drug dealer.
Okay, and this is what triggered the the August 2016 decision, right? I mean, the order.
That triggered part of the investigation. Now, in that process, there were cumulative evidence. So one thing is talking of what the claimants must have found, and the other thing is what the claimants must have found and what the Fiscalia has also found about the money laundering.
Okay, so 5 years before now, we have the Fiscalia, or the Attorney General, determining that this group of plots is most likely polluted by all sorts of things, right?
Correct.
Now, we're 5 years later. Why hasn't this land been forfeited?
You're referring to the adjacent
Yes.
one.
Why not?
I told you the situation was that it was started, unfortunately, and mistakes happen. They look at who were the list of owners of that property and didn't find illicit activity.
No. I'm sorry. I didn't make my point clear, or you misunderstood me. What I'm driving at is, if you have a procedure that starts on what seems to be fairly obvious elements, it should have been concluded and it should have led to a final forfeiture within a few months, a year or two.
The procedures take time. I'm not going to say they take time because the resources are scarce, but usually it will have taken about 3 years What happened is it was appealed, and the appeal has made it longer.
What is the legal status of the Meritage lot today from a criminal point of view?
There's no criminal question there, sir. It's a civil situation. So the Meritage lot continues to be the
Under, under provisional attachment?
it's on the provisional attachment.
5 years later?
Yeah, until there's a determination of whether there are third parties that acted in good faith or not, but that's the court. Okay, so
Moment to take the afternoon break.
yes, thank you.
Yes?
Thank you.
Okay, then we will resume at 4 o'clock. so look at David is ready. Thank you. And maybe, by the way, if you could slow down a little bit for David, it's becoming a bit stressful. But please proceed.
Thank you, Mr. President. I wanted to go back quickly to the question of the duration of the proceedings and to show the timeline of the proceedings. As I said, usually, and that's an estimate, if there's no appeals, one of these proceedings can take 3 years. Now, you have to bear in mind that it's not only Newport and the prosecutor here, you have Corte Colombiana, you have the buyers that have been intervening and coming and presenting recurses. And in fact, as you can see, the things were slowed down because of the appeals. When you see the dimensions of these proceedings, there are over 8,000 pages. And in the record only, you have you have it in exhibits 204 to 225. This is a massive, massive file. And unlike other countries or other more developed countries, it is true that resources are really scarce. The appeal slowed this. And there are 2 appeals. There was the appeal on the decision of the judge to accept the claim, the requerimiento, and there was this appeal on whether Newport was an affected party or not. I just wanted to clarify that. I'm going to go quickly to the point of the statements that the claimants have referred to you, made by members of the of the Attorney General Office. And first of all, I want to put into context these meetings. You can see at the end the investigations where they stand. Of course, the claimants will say, well, now every time that an investigation is closed is because of this arbitration. Well, no, these are different investigators, different prosecutors. And this is not a case of systemic corruption where everything is clean internally in the Fiscalia and put under the rug. You will see also claims that he was not protected, that they are disproved by the evidence. There were orders of protection issued by to the police by the Attorney General Office, allegations. But as the director said this morning, it just doesn't hold water. Why would the drug dealer be interested, drug trafficker Ivan Lopez, to have an asset forfeiture on his property that will end up, at least for him, there's no chance to recover it. It just doesn't square. As regards investigations of Ardina and Malagon, I must notice that at least 4 of those investigations were started by Mr. Seda. Nothing has been found in relation to wrongdoing of Ms. Ardila. You will have in the back all the investigations, what has been found, that there has been no wrongdoing. And as regards the coincidence in time, and I want to go here back to the timeline, what the claimants allege were coincidence in time that supposedly will show that there was that Ms. Ardila was in cahoot with Mr. Ivan Lopez. I show you the early contacts of Lopez Vanegas, when there's no mention of starting any kind of procedure. It just says, I will go to the media. You have the investigations that I referred to before by the registry, the police, the judicial police on the deeds, and that's April 2016, 18 April 2016. The case is launched. The case had been assigned on 8 April to Ms. Ardila. Mr. Vanegas, when he files the tutela that you refer, which is a request for protection because he was saying he was being dispossessed, comes later, 6th of May. You have a series of meetings in which Mr. Seda engaged in speaking to Mr. Ivan Lopez and his lawyers, including discussing swapping properties to somehow compensate Mr. Ivan Lopez. You have the order of precautionary measures that comes before the so-called meeting when they say the negotiation chapter it's closed. So coincidence? No. Coincidence if you don't look at what was happening at the asset forfeiture unit. I'm going to finish now and give the word to my partner Yasmani Fatemi, who will now address the. If you can go back to the timeline, you could see on the lower part that I just showed. Sorry.
Yeah, I've seen that.
Thank you, Mr. President, members of the tribunal. I will do my best to address the very substantial part that I have to address within the time that I have, not running through the slides. If I do, please let me know. I will go back to and frankly, this is also why we asked for a longer opening statement, because we have a lot to cover. There's a lot of misrepresentations from the other side, which we have to correct, and as you will have seen, it's difficult to cover everything. So this is really an opening. A lot of these we will go back to and also throughout this week with the witnesses and experts. So I will address now first jurisdiction, and I will start with the essential security issue. Can we please move on to the next slide? So that is, you're familiar now with it. It's it's Article 22.2 of the TPA, and the first point we're making is that this is a jurisdictional matter. You know that. I will go through that fairly quickly because I think it's obvious, but it doesn't seem to be seen that way. So I have to go through the explanation of how this reads. In fact, so. Under Article 31 of the Vienna Convention, of course, you have the ordinary meaning of the words, right? So Mr. Moulou referred a lot to preclude a party from applying measures, but he forgets the chapeau, which is what starts the whole provision, which is nothing in this agreement shall be construed to preclude. So nothing in this agreement is also a very important point. And then you have, of course, the entirety of the provision, and every single word matters, which that the party considers necessary for the protection of its own essential security interests. And of course, there you have the footnote where the parties have made sure to say what their intention is for greater certainty. If a party invokes Article 22.2 in an arbitral proceedings, the tribunal or panel hearing the matter shall find that the exception applies. This is the self-judging nature of the provision that we refer to, and I'll come back to it. So. But starting with the ordinary meaning, the words mean what they mean, and this is your starting point. But then you also have to look at the context, and talk context matters, again, under Article 31. And what you see is that this is found in the Chapter 22 exceptions. This is an exception to the applicability of all of the other chapters, right? So what is important here is that this is placed at the end of the treaty. It's not placed in the investment chapter. And so it encompasses, because it's an exception, it encompasses the entirety of the treaty. And that comes and confirms what you will have seen in the wording, nothing in this agreement. So that is an exception to the application of the entirety of the treaty, including, of course, Chapter 10, which is the investment protection. Now, still in the context, moving to the next slide, you see that Article 10.2 very clearly says that if there's an inconsistency between Chapter 10 on investment and another chapter, the other chapter shall prevail. So that means, essentially, that when a party refers and relies on essential security exception, this trumps everything else in the treaty. Again, that goes to the clear wording of the provision itself. One last word on the interpretation tools. This is the object and purpose of the US-Colombia TPA, and this is, as you see in the preamble, promote broad-based economic development in order to reduce poverty and generate opportunities for sustainable economic alternatives to drug crop production. Here, if we are given the chance to produce some additional evidence, there is evidence from at the time when this was signed that actually supports why this drug crop production is a very important intention objective in the intention of the U.S. and Colombia, specifically because Colombia is engaged in war on drugs. Now, the next point I want to make is that, again, under treaty law, you can compare the intention of the parties in this treaty with other treaties that both states have entered into. And starting with the GATT article, so on my slide 114, I believe, you see that you have on the left side Article 22 of the US-Colombia TPA, and then you have the GATT. And what you see is the GATT refers to essential security interests on the right hand, and then you have a limited list of 3 situations. And those are absent in the TPA between US and Colombia, and that's why the self-judging, which is included in the footnote, is so important, because unlike the GATT, you don't have a limited series of situations where then a review or a check may be possible in relation to those situations. Here in the US-Colombia TPA, it says nothing, just says its own essential security interest, and then the footnote says the treaty, the exception applies. It suffices that the state invokes it. If you look at my next slide, you see that the GATT, the TPA has a different provision as well, which is 22.1, which comes before 22.2, which is the essential security provision, and that is the general exception. And the general exception in the TPA refers to GATT, and so it takes GATT into consideration, but that's not the case in the essential security provision. So again, and you have it on the left side, the essential security with the footnote in relation to the self-judging nature has to be in effect, has to be read with a effet utile, and you see that there's a distinction in the intention of the parties between the general principle and the essential security, and that has to be given effect. What I cannot do now, I'm hoping at a later stage to do that, is to also rely on the travaux préparatoires, which we asked to provide to the tribunal, and the other side did not agree, so this is part of the discussion we will have later today, in relation to whether there should be a court review and whether the exception applies to the entirety of the treaty, and the travaux respond to that, and we're hoping to be able to refer to that. Now, to a final point on this, the self-judging character of this provision is supported by the interpretation of the tribunals. You will not be surprised on my next slide that this refers to GATT, because you have the essential security exception in GATT. And in the red box, you see that there's a contrario logic that has been put forward by the ICJ in the Nicaragua USA decision, where they say, essentially, you have Article 24, but for that, the court can determine whether it has jurisdiction or not. But, a contrario, Article 21, which you saw just a few moments ago, which contains the essential security interest exception, you see that the ICJ refers to that cannot be construed because it has considers necessary for the protection of its essential security interests. So this a contrario argument, you see the court says, I can determine my jurisdiction in relation to Article 24, but I cannot do it, a contrario for Article 21, because it has that language of considers necessary for the protection of its essential security interests. Some tribunals have had to look at this provision or this provision similar to this. So referring first to CMS versus Argentina, you see that the tribunal said that when there are, like the GATT, provisions where the state can invoke the legitimacy of extraordinary measures, states do so expressly. These are the 3 first lines in CMS that you see on top. And there's a reliance, you see, on which it considers necessary for the protection of its security interests. So CMS Argentina confirms that this language, which it considers necessary, means that it's self-judging. So it is when it's provided for expressly, it has to be given effect. The Deutsche Telekom versus India, the tribunal essentially decided that in relation to the treaty in that case, this wording was absent. That's why the tribunal in that case decided that it can exercise its jurisdiction to determine whether or not the provision has been invoked in good faith, because it doesn't have the which it considers necessary. So you see that tribunals have given effect to this wording. The GATT panel itself, the WTO, panel itself on my next slide, has, in relation to the Russian conduct, the case of Russia traffic in transit, has looked at that and said, well, there is a number of different interpretations possible. One is the which it considers can be given effect, and so it's self-judging, but you can also have another interpretation which the WTO panel adopted, because precisely Article 21 of GATT has the which it considers essential, but with the limitation of the three situations, which you do not have in the TPA between Colombia and the US. So that is to be given effect as well, because you don't, in the US-Colombia TPA, you just have a very general, no limitation situation where the state can determine that what it considers to be its essential security interest, it can invoke, and that would be the self-judging nature of the provision. Now, the claimants are saying that this is not admissible, we're too late, and so on. So a few words on this. On my next slide, this is the preliminary response provided by the claimant. You see that they're saying that there's no basis for which Colombia can invoke this, no new facts, no new circumstances. This is just a merits defense. Okay, so first of all, on my next slide, this is procedure order number 9. You have decided that this is admissible. And because you have a duty to ascertain your jurisdiction and may do so at any time, so you did not consider that it was appropriate to reject the defense. So that is decided, we can move on. So that, we say, is a provision that we can invoke, that goes to jurisdiction, because as you know, it says nothing in this agreement, and therefore the entirety of the treaty can be trumped. It's enough to raise it, and as you'll have seen in the footnote, it's self-judging. Now, assuming you want to nevertheless look at the merits of this question, you want to determine whether you want to say, I can actually determine my jurisdiction, I want to know if there's matter here. So what we say is that then the tribunal is bound to apply the essential security interest. Why? Again, my next slide is that you cannot do without the footnote. You cannot just ignore it as the claimants want to. They don't even talk about it. They just ignore it. So it does say the panel, or the tribunal panel here in the matter, shall find that the exception applies. You are bound by this provision. You just cannot ignore it. So this is an extremely important clarification, interpretation provided by the two states when they provided for this provision, just so that no wrong application of it can be done by tribunals. Now, the invocation meets with all of the requirements that are laid down in Article 22(2)(b). So first, Colombia has adopted measures, right? Assuming you want to go there, which we say you cannot because it's self-judging, but assuming you want to go there. So measures, asset forfeitures law, asset forfeitures proceedings, the criminal investigations that are unfolding in parallel, all of these are measures that Colombia is taking in relation to the chain of ownership of the meritage lots. They all constitute measures within the meaning of the TPA. You see, measure is broadly defined as any law, regulation, procedure, requirement, or practice. So this, you see again how broadly the treaty itself defines measures. So these measures are those that Colombia deems necessary. And again, you have to go back to the provision itself. It says measures that it considers necessary for the protection of its own essential security interests. You have to defer to what Colombia says in relation to what it needs to do, what is necessary to protect its interests, its national security interest. And this, in fact, in the Russia traffic in transit is what the WTO panel decided too. It is for Russia to determine the necessity of the measure for the protection of its international security interests. So there is a measure of deference by tribunals to the states when they invoke this type of provisions. Now, the respondent considers that the proceedings that it has undertaken pursuant to the asset forfeiture law are necessary measures in the fight against criminal organizations, money laundering, and drug trafficking. This is confirmed by the experts. Look at Dr. Pinilla, the expert put forward by the respondent. You see at paragraph 15, a very efficient way to counteract these criminal activities consists in preventing the use of ill-gotten gains, with asset forfeiture being an appropriate means to do so. And Mr. Martinez, the claimant's expert, confirms asset forfeiture traces its origin to the National Constituent Assembly and the efforts to fight drug trafficking and its related activities. The Assembly developed the concept of as a criminal policy tool to fight organized crimes through the rejection of wealth originating in illicit activities such as drug trafficking. So under Colombian law, as you see, the two experts of law accept and agree asset forfeiture proceedings by nature are aimed at fighting organized crime, drug trafficking, and money laundering. This is a serious matter. And the additional point is that asset forfeiture proceedings also allow to protect the rights of third parties. Because there's this parceling and because the units are sold to individual buyers, that's also a way to protect their rights, because if you just allow the process to go on and to continue without an asset forfeiture, at some point they may be harmed and they may be prejudiced, because then it's the ownership that they have had which will be tainted by illegality. So it's also a measure taken to protect innocent buyers. What the claimants want to do is to focus solely on the time of the launch of the proceeding and say it's too late. You have to look at the time when it all started, the time of the measures. Well, with respect, and that's my next slide, the measures are ongoing. The measures started, asset forfeiture started, they are ongoing, and there are judges deciding the matter. First point. Second point, Article 22(2)(b) does not establish any time limit for the invocation. You will not see anywhere that there's a time limit or any limitation to the right of the state to invoke this provision. And to decide otherwise would be to not give any effect to the provision and render it meaningless. The next point is that under Article 1024D of the TPA, there is no waiver to any objection on jurisdiction. So you see here that we have reproduced the provision. The respondent does not waive any objection as to the competence or any argument on the merits merely because the respondent did or did not raise an objection under this paragraph. So again, there is no waiver. Colombia is in its right to raise and to invoke this exception. And finally, when the invocation is made, you look at the time of the invocation. You don't look at before. And if you look at asset forfeiture law, this is even before the arbitration, so the argument makes no sense. It's neither here nor there. You have to look at the measures at the time of the invocation. I apologize for my pace. I have so much to tell you. So in any event, we say Colombia has raised this provision in good faith. Why? You see again, and the deference is important. Even if you decide that this is not jurisdiction, even if you decide that you want to actually look and make an assessment of whether or not this was in good faith, even then you have to give a deference to how Colombia determines its own national security interests. And the standard is minimal. This is what you see again in the WTO panel decision that I refer to. It is left in general to every member to define what it considers to be its essential security interests. And you also have, in the case of the WTO case of Saudi Arabia, measures concerning the protection of intellectual property rights. You see that here the panel has referred to a minimal standard to enable an assessment of whether the challenge measures are related to those interests is not a particularly onerous one and is appropriately subject to a limited review by a panel. So even in the GATT world, in the WTO world, where you have the enumeration, which does not exist in this case, even there, the WTO panel has said that it's a limited review and you have to defer to how the state defines its own security interests. And frankly, that's quite logical because nobody's in the mind of the state. Nobody knows how the state is actually looking at such serious measures and such serious situations as war on drug and drug trafficking and money laundering. So, and my next slide is just an example of how seriously Colombia is taking this, the fight against organized crime, money laundering, and drug trafficking. You see this is a speech of the president in 2014, and this is important because this is the time when the TPA was signed. So, and that goes to the intention of both parties when they accepted to have that, that provision in the TPA. And you see that there's here a reference to the fuel of the conflict in Colombia is without a doubt drug trafficking. And there is a reference to war on drugs. And you see on the right side that there's also the General Assembly of the Organization of American States, also referring to the drug policy debates. So no matter how you look at it, this is an extremely serious situation. And Colombia's determination that it is its national security interest to take measures, including assets for future proceedings, to protect its national interest, this is something that has to be given deference to. And looking at, again, the how you look at this here, the respondents' measures were adopted for the protection of its national security interests. Again, referring to WTO decision in Russia, you see that the standard, the minimum standard, is one of plausibility between the measures and the interest. And you see here the panel must therefore 7139, the panel must therefore review whether the measures are so remote from or unrelated to the, here is the 2014 emergency, this is the Crimea situation. So it's a plausibility. You look at whether there's a plausible, the measure is plausible to address the situation. First of all, you have to determine that there has been a breach of the treaty. This is again, here I'm still in my alternative argument, which is living assuming that this is a merits question, it's not a jurisdiction question. There cannot be a violation of the treaty if the essential security exception applies. And in this logic, it excludes the application of the substantive obligations of the treaty. This is what you see in CMS in relation to Article 11 of the treaty, in that case, Argentina-US BIT, where you see on the bottom of the page, the last 3 lines, you see there's a reference to Article 11. Article 11, if and for so long as it applied, excluded the operation of the substantive provisions of the BIT. This is the logic. So even assuming it's not self-judging, even assuming you're in the merits, you have to consider that this is exclusion of the substantive obligations of the state under international law. Now, my next slide is the reason why there cannot be compensation, there cannot be reparation, unless and until a breach has been found, right? So, Mr. Molu here said earlier that, well, again, Colombia can continue taking its measures, but, you know, this doesn't exclude compensation. First of all, you'd see that nowhere in the provision, nowhere in 22.2, it says preclude the party from applying measures. And as we just saw, this sort of provision, at the very least, if it's a merits question, it excludes the applicability of the substantive standard. To support his view, Mr. Molu referred to the Ecuador decision against Colombia. Here, with respect, this doesn't work either. That Ecuador was rendered based on the Canada-Colombia FTA, which has a completely different provision. It's a general exception. It's not a national security interest exception. It's Article 22013 of the Canada-Colombia FTA, which says specifically, for the purposes of Chapter 8 investment, subject to the requirement that such measures are not applied in a manner that constitute arbitrary or unjustifiable discrimination, etc., etc., and then there's the protection of environment. So you see that the provision itself in the Eco-Oro says there's a number of conditions, so it should not be arbitrary, unjustifiable, it should not be discriminatory, and so on. And it says for purposes of the investment chapter. So of course the tribunal will look at whether or not there will be a compensation possible because there are conditions put there in relation to environmental protection. This is not the case here. This is not what you have here. Here again, you have Article 22.2b, which refers very broadly to whatever either state, by the way, Colombia or the US, can consider necessary for the protection of its own essential security interests. This is what it says. So the provisions are completely different and the analogy doesn't work. And my final point on this slide is that simply under you're an international tribunal. You can grant compensation if you find a breach of the treaty. Absent a breach of the treaty, you cannot give compensation. So again, it's neither here nor there where they say, well, just give us compensation. Forget about all of the ongoing procedures in Colombia on asset forfeiture. We may retrieve it at the end of the day, but it's fine. Give us compensation in the meantime and we'll go happy. 200 million, we're very happy. It doesn't work that way. ILC articles, responsibility of a state. There is an internationally wrongful act of a state when conduct consistent of action or omission constitutes a breach of international obligation. You would have to find a breach first. You cannot give reparation without a breach. And as you know, the national security interest just excludes the substantive protection of the treaty. So that is also the consequence of the national security interest. So again, you cannot give any compensation, but unless you have found a breach, which you cannot, because this is the provision, the mechanism of Article 22.2b, which Colombia has raised. And again, if we are allowed to provide the travaux préparatoires, we will be able to discuss some more what the treaty, the two states have determined to be the consequences of the invocation of this provision. And to finish, in an event, you cannot determine the liability nor award compensation because this is ongoing. This is just too premature. It's premature for you because the asset forfeiture participate what's going to be done because you don't know the end result of the asset forfeiture proceedings. So on my next slide, should Newport, and this is really important for you to understand, should Newport be recognized as bona fide without fault third party, which it can, because the proceedings is ongoing. The Colombian courts are seized of the matter. Our friends on the other side are not claiming that the judicial process in Colombia is wrong. They are saying specifically that they're not complaining of denial of justice. And in fact, they're very happy with the decision of April, 2 weeks ago, or April 22, where the Bogota court accepted them as an afectado party in relation to the asset forfeiture. So let the courts decide. Let the court take this in the normal course of what an asset forfeiture proceeding should be. And at the end of the day, it may well be that Newport will be recognized as a bona fide without fault third party, in which case the precautionary measures will be lifted. Newport would be entitled to dispose of the land. It would be excluded of the asset forfeiture. Action or omission of the authorities that has caused harm, you can seek damages from the state. Yes, that's in the Constitution of Colombia. So they are not remediless. They have remedies and they can seek damages from the courts in Colombia in the event that the courts at the end of the day find for them and find that Newport is a bona fide without fault third party. So if anything, this all shows that the damage that they're complaining of is not sufficiently certain. It's actually uncertain. They have not incurred any damage. Now, one final point on the MFN clause. This is just a magic trick. They like to go to MFN, and actually, you saw it was quite fast. Let's just look at the MFN provision 10.4 of the TPA. You see that there's again a footnote on the second provision 10.4.2 in relation to most favored nation, relation to investment, where the states have said, you see penultimate line, that it does not encompass dispute resolution mechanism, so it doesn't apply to arbitration. The reality, and that's my next slide, you see that the claimants have failed to set out the precise basis on which they seek the application of 10.4. Is it investment? Is it investor? We don't know. They have failed to set out what is the better treatment they are seeking. They just generally say, and you heard Mr. Muller earlier, yeah, the Swiss investor is better treated. How? On what basis? The better treatment has to be based on comparison. You have to take a provision and compare to some other provision and to see what exactly is the problem and where is the better treatment and what is the better treatment. Here is nothing. It's just, oh, we want a whole in our treaty. We want to import the whole in another treaty and import the whole. That doesn't work that way. That's not what MFN clauses do. And they fail to recognize the express exclusion, in fact, of the entire treaty from, which is the consequence of Article 22b, which includes the MFN provision itself. Again, you remember nothing in this agreement. It trumps the entirety of the treaty, including MFN, so they cannot invoke the MFN provision, and that is also the effect of 22b. And by the way, to the extent that they like to refer to doctrinal work on whether or not arbitration is a substantive right, as you know, even if arbitration is a substantive right, as you will have seen from CMS, this type of provision also excludes the applicability of substantive rights. So again, this is neither here nor there. And very quickly, I don't have the time, on my next slide you have CMS and Siemens, and you see that both tribunals have said that, and on the right side you see Siemens claiming a benefit, second line, by the operation of an MFN clause does not carry with it the acceptance of all the terms of the treaty. You have to look at other terms of the treaty involved. You cannot just forget about a very important provision and just make it as it didn't exist. And of course, as you know, it also refers to the public policy considerations judged by the parties to a treaty essential to their agreement, and this is exactly the situation here. And CMS on the left side, it refers to the MFN clause not to be able to play a role in that case. It was, again, Article 11 of the treaty in that case. And the CMS tribunal said you have to, that's the treatment point. If you want to have a better treatment, you have to find another exception provision in another treaty and then compare and look at which is the better treatment, which they don't even bother doing here. So this is for now, the entirety of our argument on the essential security. And you see, regardless of how you look at it, jurisdiction or merits, this is something that it has been invoked in good faith by Colombia in relation to extremely serious conduct and extremely important provisions and measures taken by Colombia to protect its national security interest. And we ask you to, first of all, recognize that it's self-judging, and even if you're not with us on that, you have to give a very heavy deference to Colombia when it determines what is its national security interest, essential security interest, I'm sorry. Quickly on the other jurisdictional issues, not a protected investment under the TPA and ICSID convention. This I will go relatively fast. Of course, you know this, but I have to go through it. The claimant's investment does not have the characteristics of an investment. This is in reference to the TPA. On my next slide, you see that, of course, here you're at ICSID tribunal, so it's a double barrel test. You have to satisfy both the ICSID convention and the TPA. ICSID convention, you have the arising directly out of an investment, and you're familiar, of course, with the test that there has to be a commitment, risk, and duration Salini test. Under the TPA, you see the TPA itself provides for, yes.
Sorry to interrupt, Ms. Benefitemi, and I want to go back to the essential security interest. You're rushing through this, so I was trying to gather my thoughts. So apologies for going back while you were already getting into your other argument. But I mean, I understand your argument to be that this is a jurisdictional exception. So essentially, whatever Colombia says, that is the end of the matter. We would not have the authority to look into it almost at all. I understand that, but your alternative argument is that if the tribunal is not with you in this jurisdictional argument, you've argued that Colombia has made or has applied the exception in good faith. and I may be not you may have phrased it differently, but in other words, Colombia has either made a good faith application of the law, Colombian law in this case specifically, or a good faith application of the exception, whichever. But if we're into the alternative argument, what is your position into the tribunal looking at that matter, whether Colombia has applied it in good faith or not? Or put, since you made the comparison to other treaties, and specifically I think it was the Canada-Colombia Treaty in the environmental context, where it says, provided that measures are not applied in a discriminatory, arbitrary, and so on and so forth manner. What is your position in your alternative argument of what this tribunal could do? Can we look into whether it has been applied in good faith, or, but another way, whether it has been applied arbitrarily or discriminatorily, and so on and so forth?
Thank you for the question. Assuming you're not with us on jurisdiction and you determine that you have to assess whether or not Colombia is in its right to invoke the exception, right? So that question, we say, is one where you still are bound by the footnote also, which says that it's self-judging, right? It's the tribunal shall find that the exception applies.
Yes, but that sort of brings you back into the prior argument. If it's self-judging, then we have nothing to say, and whether you call it jurisdictional or something else, you're basically kicking us out of the room, saying this is for us to determine. You don't have a say in it. So we're into the alternative argument where we're not with you in jurisdiction. And the question is, what sort of a say do we have into what you have now portrayed, that it has been a good faith application of the law in this context, and of a good faith application of Colombia's, or a good faith determination, if I may put it this way, Colombia's essential securities interests? Can we look into whether it is good faith or not? And I appreciate that the footnote, I think, I don't want to put words in your mouth, but I suspect that you would tell us, if the tribunal determines that it has been in good faith, then the footnote requires the tribunal to have deference to Colombia and apply the exception. But otherwise, what are we to do?
To be clear, that's why I wanted to go back to the footnote, because we cannot ignore the footnote, right? So there's 3 levels, I would say. Level 1, it's a jurisdictional question. You simply cannot determine whether or not you have jurisdiction. It's enough that Colombia raises this for the entirety of the arbitration to fall, because you do not have jurisdiction, to the extent that Colombia says this is all about my national security interest, essential security interest. I'm sorry.
Let me stop you there and then put it point blank. The footnote says the tribunal or panel hearing the matter shall find. That to me suggests that we have a say in what the tribunal shall find. It doesn't say the tribunal shall accept whatever the party says. It says the tribunal shall make a finding. So that's point blank. It seems to me that we have a say under the footnote.
Okay. If I may finish, then I'll just do the sequencing. Jurisdiction, we say, in our primary argument, it's jurisdictional. You cannot go to the determination of the substance of dispute, because we say you do not have jurisdiction to do so. Shall find that the exception applies. Shall find, you can make a determination, which is I find that the exception applies, because I have to, I shall, it's my obligation. So that's our primary position. The second position is assuming you think that you have to make some type of assessment, right? So that type of assessment, if it's on the substance of the dispute and on the substance of whether or not this provision has been invoked in good faith, then you still are bound by this. You shall find that the exception applies, and it's not that it's simply that the exception applies, and therefore to the exclusion, to the preclusion, the agreement can not allow you, the exception cannot allow you to make a determination on the measures that are taken by Colombia in order to address its and what it considers to be its essential security interests. It has to be a plausible, now going to the third level. So this is the second level. Let's assume you determine that, no, I actually have to determine both that it's raised in good faith, and I also have to determine the substance, the good faith substance of that. And that's probably your point about I have to find something, I have to make some type of assessment. If we're there, then that is the plausibility argument that I mentioned earlier. And what we say, and that's the slides that I admittedly a bit fast because I don't have much time. It's the deference that the WTO panel, for example, and the other tribunals have said when an essential security interest is raised, when you have a terminology that says that it considers, that the state considers to be its own essential security interest, you have to give deference to that determination. You cannot go as far as saying whether or not these measures are the appropriate fully of the situation. It has to be plausible, right? It's the whether or not it's very remote from the objective, which is a fight against drug trafficking, fight against money laundering, or whether it's quite plausible that Colombia, in taking the measures that is to what it says is its essential security interest.
Which is the definition of a prima facie test, right?
On which side? On
determining,
demerits?
yeah.
Well, yes, you can say it's prima facie, or you can say I on the face of it, I see it's plausible that the measures taken are designed to address this situation and this objective. But you have to stop there, because you don't have, and that's what it says, and you have again to give meaning to this, because you can you have a limited level of determination. You have to give deference to what the state itself, otherwise you're not giving effect at all to what it considers to be for the protection of its own essential security interest. You have to give deference to the state the way that it determines this. Now, again, if we have the travaux préparatoires, I can give you more detail about this, because this goes to the intention of both parties, both the US and Colombia, when they entered into this provision, as to what they actually meant by this, and the sanction and the consequences of the invocation of this provision.
Just a follow-up question. So to start with the national interest, isn't that defined in the forfeiture law, the combat against drug and traffic and money laundering? So isn't that defined in that law, what Colombia intends to apply and to do in this respect?
Yes, I see. Probably what is stuck in your mind is the argument that is made. The argument is made that you had to raise it before. Is that the question?
That was not the argument. The law contains this exception that the bona fide purchaser cannot be subject to the forfeiture proceeding. So isn't the expression of the national interest contained in that law with that exception?
Well, it's the whole purpose of the asset forfeiture proceeding to determine whether someone is a bona fide without fault party. But you have to go through the motion of the actual proceeding itself. And the courts are seized of that matter, which is what we're saying. The courts are seized of this matter. The courts are making determination as to whether Newport, which is now an affected party, and it was before, it is again, it can make submissions, it can make its views
I
known, and that will be
I
determined.
understand that argument.
Yes.
But on the international law level, when we have to look at how does Colombia define its national interest in this regard, so we have to look into the law, and the law provides certain proceeding and certain thresholds and certain standards and certain protection, but it also provides for this exception of a bona fide acquisition of a possibly tainted property. So my question is, isn't that then part of the consideration that this tribunal has to carry out?
Well, this is in the event that you don't give any effect to 22.2b, which would be a problem, because again, this is a right for Colombia to raise the exception, and as the states have said and confirmed, the exception applies and the tribunal shall find that it applies. So what you're saying would be in the event that you completely ignore this and you go into the merits and the substance, and we're very comfortable with the merits, that's not the issue. It's whether or not how the law functions, whether or not, in what conditions, whether there was due process and so on and so forth. So that will be on the merits, and will be an alternative when we argue all those points, that the exceptions and the proceedings that are allowed by Colombian law, whether those were followed, and we will argue that on the merits, but that is again in the alternative. And our point is that your mandate stops before that. You have to give effect to what Colombia says is essentially security interest, because at the time when it was raised in circumstances where there were new elements, new circumstances in relation to, and you may remember, I think it's slide 47 of our opening, where you have the whole chain. You have an entire chain of relationship with the Oficina, which you can now see. So this is extremely serious. If Colombia says, I'm looking into this and I'm investigating this, within the asset forfeiture proceedings and that legal framework, that is for Colombia to do. Colombia says, it's my essential security interest, let me do it. And this is what this provision says. You have to give effect and deference to what I say and what I consider to be my essential security interest. And those built-in exceptions are part of that. So you have to trust Colombia when it says, and especially that there's exceptions and due process and everything that's built in Colombian law. And again, they're not complaining that the courts are not doing their job. So the courts are actually looking at this. It's an ongoing process, and therefore it's an ongoing measure. The measures that you have before you are ongoing.
But if the If the interpretation of 22.2b is so clear in the two options you have outlined, either as a jurisdictional impact or on the merits, why do we need the travaux préparatoires at all?
Because we want you to understand the intention of the parties, and well, I'm going through what we always do, which is when you interpret a provision, you are going to interpret this provision. If you are going to interpret this provision, we say the language is clear. But if you look at the language, I'm just looking at Article 31. You have to look at the context, which I explained. You have to look at object and purpose. You have to look at other treaties and how the same two states have entered into and have looked at the same type of provision in other treaties. And you have to look at the travaux, because that's also where you have the intention. I'm just arguing this to give you comfort that what we're saying about how you should read this is right. So it's just the interpretation of this.
How voluminous are these travaux that you would like us to look at? And does the well-known caveat apply that one finds in the travaux préparatoires?
Well,
no real explanation except in support of what one has decided to argue to begin with. You know the classical caveat about travaux préparatoires, right? That they serve to back up whatever opinion one has, because you can always find all sorts of things.
Well, with respect, it depends on the travaux, it depends on,
I think
the substance.
You and I have evoked travaux préparatoires in a different context, right?
Yes, we have, and in that context, the travaux préparatoires were extremely clear about the state's intention. So it's the same here. It's going to be extremely clear on the state's intention as to what they meant when they drafted this provision. So to answer your question, I will address this later because it's the housekeeping matter before us. But we have shared with our colleague on the other side the entirety of the travaux, which is 186 pages, and we did identify to them the pages that discuss essential security interest. Those are 14 pages, and we have shown that to them already. Yes, I'm being corrected that the entirety is 3,000 pages. The 138 pages that were provided is relevant to more directly to this chapter, I believe. And then on essential security is the 14 pages that I referred to. Does that answer?
Not completely, because I mean there is a sorry. Well, should we discuss this at some later stage, or?
Yes, possibly.
Okay, I don't mean to waste your, or I don't mean to eat some of your time. Also.
Not at all. So I want to make sure that I've answered also your question. Thank you. So it's this three-level sort of decision tree that we propose.
Your answer is clear.
Thank you, thank you. So and then of course you have our slides on the plausibility and also what I discussed about why this is in fact and I'm at my slide 137, right? That the measures adopted are indeed addressing the essential security interests. If I may then go back to investment. I was at slide 153, I believe. May I ask how much time is left? Maybe I should start there.
1 hour.
I will do my best. So the TPA itself, you see, defines the characteristics of an investment. You see that it refers to 153. So commitment of capital or resources, assumption of risk, and expectation of gain or profit. This is the definition in Article 1028 of the TPA. On my next slide, you see that the case law has said that in similar provisions, that this is a global assessment that must be determined by the tribunals. And you see this is in reference in the SEO decision on the Chorus FTA, and it refers to the global assessment, as you see on paragraph 96. Now, if we look at the claimant's purported investment, you see that the commitment of capital, so based on these criteria, the commitment of capital or the resources has not been significant. Pursuant to the financial statements of Newport between 2013 and 2017, you see that there has been a payment of less than $2 million, so that is not significant at all. And the further point, which is related to this point, is also that the Meritage project was mainly financed by the pre-sales of units to buyers. So there's not a lot of risk that's taken by Mr. Seda and his partners. It's actually sold and pre-sold to the buyers. And you see, and this is also a reference to SAO, where any capital resources committed are incapable because of their insignificance of contributing in any meaningful way to objectives of the TPA. So the significance matters in this global assessment. And the next 2 points, which I will be fast on, is a matter of logic, in fact. If you have not contributed in any significant manner, the assumption of risk is not there either. You only risk what you contribute. If you have not contributed much, you're not risking much. And likewise for the expectation of gain or profit. The next point is the encumber nature of the rights over royal royalty. My next slide, you see this is the pledge of the shares as collateral in favor of Downey South LLC, the claimant's funder in this arbitration. And you see here the proof of the collateral on the left and right hand, and how management company, the parent of Downey North, is a party in this arbitration. There was some debate about that. We're still not done with that debate. What is important on my next slide is that they have, this is an email of the claimant of 20 April, they have refused to disclose the financial interest of Tenor through Downey North. And we say this is a very serious matter. This is part of the also the housekeeping matters that we have to discuss. Why? Because Mr. Amarillo, who is sitting in this room, is the co-executive chair of the board of directors of Eco Oro, the same decision that was referred to by Mr. Muller earlier, and he took on that status 1 month after the award was rendered in the Eco Oro decision. So what we say is that yes, there was document production. You did not order the financial arrangements. What we say, we're not saying give us the financial arrangement. We're not asking you to reopen the matter. We are saying, however, and this is very important, we need to know what is the exact financial situation. We need to know what is the financial interest and who's the real interested party here. And if there's a similar situation where Mr. Amarillo will have, and here since he's presented as a party representative, will have a financial through Tenor in the financial interest in the case and in the dispute. So this is important. This goes to your jurisdiction. Who's the claimant in front of you? This is important enough that you actually would want to know the financial interest. And by their own word, they're saying that they have not disclosed the financial interest. Now, my next point is that the vast majority of the claimant's claims do not concern the claimant's investment in Meritage. So you know that here, again, the double barrel exit convention, Article 25, your jurisdiction extends to any legal dispute arising directly out of an investment. And you know from CMS Argentina that this provision excludes disputes that do not rise directly out of the investment concerned. So the investment concerned here is the Meritage, and I will come back to that. And so that's exit. Now, TPA, you know that the TPA is saying that the Article 10.1.
May I just interrupt, because David is asking for a 5-minute break, and I think he's perfectly justified.
Absolutely.
Because this was very, very fast. And
with great
so
pleasure.
please take a break. 10 minutes, okay?
10 minutes.
10
Understood.
minutes.
Okay.
Thank
I
you.
didn't mean to,
No, 10 minutes.
I didn't mean to interrupt in the middle of a point.
No,
Not
but
at all.
this was fantastic how you followed the speed of this pleading. Fantastic.
Thank
10
you.
minutes.
Okay.
Disculpen, tiene el micrófono encendido.
So we will resume now and give you the floor again.
Thank you.
Mrs. Benefit-Demi.
Thank you, Mr. President. I was discussing the TPA and how the TPA defines the relevance of the investment. So you have Article 10.1.1 here, which is very close to the NAFTA provision, measures relating to covered investment. And this is what you see in the Metanix decision, where it was characterized as a requirement of a legally significant connection between disputed measure and the investment. So this is what the US says on my next slide. I have noted that our friends on the other side never referred to the submissions of the US, which is actually very relevant to how the US, as much as the expert report of BRG, only 31% of the claimants' damages claim concern damages in connection with the Meritage project. You see that there's out of the total of 203 million, 64 million is the Meritage, the rest is of the other projects, and therefore those are not legally significant to under the TPA to the measures complained of. Quick word on Mr. Haas. As you know, this is an investment which is held through a discretionary trust incorporated in the Bahamas. What is important is that here you see on my slides 168, you see what are the powers of the trustee. It is important to recognize what type of trust we're talking about. If it's discretionary and the trustee can withhold distributions, which is you see in the second box, and the third box, it can exclude classes of beneficiaries for the purpose of the settlement. This does not mean that Mr. Haas controls. It's the control is with the trustee, and so we say that because of that, it's not the relationship that's required by the treaty. And on my next slide, you see that tribunals have considered that discretionary beneficiaries of discretionary trust cannot be deemed as having investment. That is the Argual Uruguay decision. And again, for lack of time, I will not quote. You have the relevant excerpt on screen. Now, moving to the merits, for lack of time, I will, with apologies to the tribunal, to really be a bit more superficial than what I hoped to do. But I want to start with one remark. You heard first Ms. Champion say this morning the claimants are not entitled to protection in Colombia's view, are not entitled to international law protection. That's wrong. We're not saying that the claimants are not entitled to international law protection, because she says they assume, the claimants assume the risk of business. That's not the point. For the very technical reasons that we have developed, there's no jurisdiction, but it's not that they're not entitled generally to international protection. Then Mr. Mulu says, how does this come to be? And feigning surprise that this investor coming to Colombia and be treated the way that they say he was treated. The point is that if, as an investor, someone comes to Colombia to invest in real estate in the region of Medellin, which is engaged, and it's historical. It's Colombia, and especially in that region, is engaged in a war on drugs and drug trafficking and money laundering. The least that investor could do is, and the expectation that investor should have, is that it will be subject to Colombian law. Colombian law will apply, and Colombian law includes asset forfeiture in relation to assets, including in real estate, including in Medellin. So the expectation is that Colombian law will apply. It's not that international will not apply. It's that you have to respect Colombian law and you have to comply with what it says, and you have to go and invest within the legal framework that exists. And also you have to, and that was addressed by Ms. Herrera Bernal, you also have an obligation of due diligence. So you cannot then not do your due diligence, go into a legal framework which is complex enough and with the conditions that we're seeing and what we're seeing unfolding in the criminal investigations, and then say, I'm going to go to international tribunal and ask them to determine that I'm a bona fide buyer and therefore I'm entitled to compensation. It's not the way it works. The way it works is that they are engaged in a court proceeding. The courts in Colombia have the authority to determine on the asset forfeiture proceedings whether or not there's a bona fide third-party buyer, and then If they have a problem, then they can go to arbitration to the extent that they can. But otherwise, everything else is premature. So with that very brief introduction, I really will have to go fast. And with respect to the tribunal, refer you back to both our written pleadings and also our slides where we try to summarize the position. So on expropriation, that's the first standard. Of course, you have Article 10.7 of the TPA, and you have the conditions under Article 10.7, but these are the conditions for the lawfulness of the expropriation. What we say is that there has to be an expropriation first. Before you determine whether it's lawful, you have to determine if there's an expropriation. And what we say is that the assets for future proceedings are not expropriatory in nature. So, and this was addressed by Mr. Mulu, Annexed 10b. It's an important annex because it determines the framework that we're looking at. First, you see, Annex 10b(1) refers to actions cannot constitute an expropriation unless the action interferes with a tangible or intangible property right or property interest. This is the first condition. And then paragraph 3 determines the conditions for an indirect expropriation, and the allegation here is that there has been an indirect expropriation. So let's look at the requirements. It's a case-by-case, fact-specific inquiry, and you have the 3 conditions, and I will take them one by one. Next slide, first factor. These are factors that are determined by the TPA. Economic impact of the measure. Here again, it's important to look at what the US says in its submission. They don't discuss it at all. The US says in paragraph 25, I quote, the claimant must demonstrate that the government measure at issue destroyed all or virtually all of the economic value of its investment or interfered with it to such a similar extent and so restrictively. And you have the case law that we are provided, Busta and AMF. AMF is particularly interesting because it refers to, on my next slide, 180, it refers to temporary sequestration of disputed assets during bankruptcy proceedings. And the tribunal in that case said that amounts to expropriation only if they were carried out unlawfully, in bad faith, or with an expropriatory purpose. And so these are the type of standards that you're looking at. Here, on my next slide, you see that there's no evidence that the asset for future proceedings had a permanent economic impact on the Meritage project. First of all, the asset for future proceedings did not and could not result in a permanent and irreversible deprivation of their alleged investment because the claimants did not have any in rem right over the Meritage project that could have been subject to permanent and irreversible deprivation. The important point to note here is that under Annex 10b(1), you remember it refers to property rights, right? So there has to be property right, which is not the case here. Then it's undisputed that the asset for future proceedings are ongoing before the Colombian courts. There was discussion about the Corte Colombiana confirming that it can still go a standard for you to find if there's expropriation or not. The second factor, interference with reasonable investment-backed expectations. Again, you have the submission by the US. This is an objective inquiry, says the US, of the reasonableness of the claimant's expectations, which may depend on the regulatory climate existing at the time the property was acquired. And it's exactly what you said. You have to look at the regulatory climate at the time the property is acquired in 2012. So here again, on my next slide, the claimant could not have reasonably expected that the Colombian authorities would refrain from initiating asset for future proceedings against a law that is tainted by legality. And you look at the framework here. So the claimants knew or should have known that assets for future proceedings are not subject to any statute of limitation. This is important. There's no statute of limitation and cannot be waived by the state. If you look at how this has worked in the past years, between 2011 and 2014, you see that there's almost 150 decisions issued on asset for future proceedings in connection with almost 1,000 assets. This is the legal framework we're looking at. And again, as we said, the claimant's own due diligence was highly deficient, so it cannot give rise to objective and reasonable expectations. So this is what you have to look at in order to determine whether or not there has been expropriation. The third factor, the character of the government action. This is, and referring again to the US submission, it is regulatory in nature, and CME, you remember, discusses the distinction between deprivation on one hand and, I quote, ordinary measures of the state and its agencies in proper execution of the law. This is what you are looking at here, proper execution of the law, and ordinary measures, which are the asset forfeiture proceedings when you have situations as the one we have here. Again, the U.S. also says that domestic decisions of domestic courts did not give rise to a claim for expropriation under Article 10.7.1. And here, the proceedings are bona fide and non-discriminatory measures. They were initiated and conducted in accordance with the law and the Constitution in Colombia. As you know, and you have here Article 34 of the Constitution, which makes the distinction between asset forfeiture on the one hand and confiscation. So under Colombian law, the two are different. So it's not by nature expropriatory. And finally, the asset forfeiture proceedings are pending before the court, as you know. If the court's decision cannot give rise to claim for expropriation, as the U.S. has mentioned, a fortiori, the decision of prosecutors in relation to proceedings that are still pending cannot be an expropriation because it's not final. It's not even before the judge yet. So we are at the stage where we are going to have a decision by the courts in the future. The second point in Annex 10B of the TPA is the legitimate exercise of regulatory powers. This is what you have on my next slide. You have paragraph 3B of Annex 10B, except in rare circumstances, non-discriminatory regulatory actions to protect legitimate public welfare objectives, such as public health, safety, environment, do not constitute indirect expropriations. And this also is confirmed in the case law. You have an excerpt from Suez versus Argentina. So it's the legitimate public welfare objective, and the case law has also looked at other factors such as due process of law, non-discrimination, and bona fide conduct. If we look at them quickly, the first legitimate public welfare objective, the experts of the claimant acknowledge that the purpose of asset forfeiture law is to fight organized crime. This is an excerpt from Dr. Medellin, first report. Principle of asset forfeiture expressly in Article 34 of said convention, still in force today, as an instrument for the pursuit of assets acquired through illicit enrichment at the expense of public treasury or to the serious detriment of social morals. The purpose of such forfeiture was to attack illegal activities such as drug trafficking and consequently obtain social and economic stability of the country. So you see, again, this is a very legitimate objective, public objective that Colombia is pursuing. And again, it's doing so in accordance with the law and in a proportionate and justified manner. And you have here references to the exhibits that show that. On due process, the proceedings were initiated and conducted according with due process. Again, this is a reference to Dr. Medellin, and that the law, as you said, Mr. Chairman, there are fundamental guarantees in the law. And we say, and that is reference to our slide 47, there have been multiple opportunities for the claimant to present their case and submit evidence. Through Newport, they could do before, they can do now. They are admitted as an affected party. So the proceeding will continue and they will have a full opportunity to make their claims and before the courts in Colombia. The third factor is the non-discriminatory basis. Again, this is a fact-specific assessment that looks into similar cases and whether there's a difference in treatment without reasonable justification. You see that by 2018, there were close to 3,500 ongoing asset forfeiture proceedings in Colombia. And you see that between 2011 and 2016, 292 decisions were issued on asset forfeiture proceedings in Colombia, resulting in 1,405 assets being forfeited. And you see the number of precautionary measures taken in that context, more than 13,900 assets subject to precautionary measures. So this is the similar context and the similar circumstances and the like circumstances. So the claimants are not mistreated or treated any differently as compared to these circumstances. And the final point is that if there is any differential treatment that has to be justified, despite Mr. Lopez Vanegas' claims over the Meritage law, the claimants continued with the project of selling units to third parties. This is important because, again, they have an obligation of due diligence, and at the very least in 2014, when Mr. Lopez Vanegas made claims at that point in time, there was an obligation to raise that issue with the Fiscalia, which was not done. The final point is the bona fide application of the asset forfeiture law. This is what we say, and this relates to the corruption allegations by the claimants about the Fiscalia. This is a very serious matter, in fact. First of all, if they're making an allegation of corruption, they have the burden of showing corruption. They can just not make allegations in vaguely and just say you have to find corruption. At the very least, you have to find compelling circumstantial evidence, and here we refer to ECE versus Czech Republic about direct evidence or compelling circumstantial evidence. On my next slide, I want to address the fact that the standard precisely arbitrators enjoy a wide discretion to evaluate evidence regarding corruption, and in light of the circumstances of the case, here there's a reference to Professor Gaillard's article on the emergence of transnational responses to corruption. In the case at hand, the issue is that the seriousness of the accusations. You heard earlier that there's an allegation essentially that the entirety of the Fiscalia is tainted by corruption, but because two persons, Ms. Malagon and Mr. Adila, supposedly engage in some type of wrongdoing, but they cannot make this allegation generally and say you have to find corruption. This is a very serious accusation, and here you have a reference to Karki versus Pakistan involving officials at the highest level of a government, and so you cannot just do it lightly. It has to be clear and convincing evidence, and they have not brought that clear and convincing evidence at all. So the highest threshold of proof of corruption in this type of situation is justified by the seriousness of the accusation and in the context of collusion with criminal organizations specialized in drug trafficking. And also what is at stake here, as you know, is the fight against organized crime, money laundering, and drug trafficking. It's important to emphasize here that there has been no finding of corruption. This is a very important circumstance to keep in mind. And the fact that they never say, in all of their innuendos, they never say what benefit the Fiscalia could ever have had by assisting or helping Ms. Lopez Vanegas. You just have thrown at you a number of, circumstances or allegations, and they just refer to coincidences. Coincidences is not proof; it's not evidence. You cannot just based on coincidences which are not explained, find corruption in the entirety of the Fiscalia. This is a very serious matter. So here on my next slide, you have references to the case law. Even if, and this is our alternative, even if you were to look at red flags, the red flags have to exist in the first place, and they don't, right? This is Union Fenosa. There have to be dots. You have to link the dots, but there have to be dots. And the same thing in ECE versus Czech Republic. And on my next slide, we have this table. Ms. Herrera Bernal didn't have to go through it. I will go through it quickly. The purple, the red flags. On the left side, you have the allegation, and the reality on the right side. The second red flag, so-called red flag, coincidences in timing between asset forfeiture proceedings and alleged extortion attempts. With respect, and here you will have to go back to the timeline, and you will have heard Ms. Champion say that some facts remain elusive, yes, to say the least, elusive. So you actually look at the facts, you actually look at the timeline, and you see that the initiation of the asset proceedings predated the alleged extortions that Mr. Seda complains being a victim of by Mr. Ivan Lopez Vanegas and his lawyers. So the timing doesn't match. Now, on national treatment, Article 10.3, again, the U.S. submission here on my next slide refers to this being a prevention of discrimination on the basis of nationality. This is also confirmed by Total, Argentina. There has to, here on my next slide, investment tribunals have found that the treatment is not breached when the investor is not targeted because of his nationality, but because of his conduct in the host state. And this is an interesting precedent. You look at the bottom line of 467 on the slide. The tribunal in that case found that the claimant was targeted not because of his nationality, but because rather than adhering to the terms of his permits, he decided to embark on a materially different operation outside the Jebel Waza. This is Al-Tamimi versus Oman. So it has to be a discrimination based on nationality, which is not the case here. And the claimants have acknowledged the 4 elements that must be considered for the breach of national treatment standard. You have them on the slide, and I will go through them again quickly with apologies. The first 2, which are there has to be foreign investor having received treatment that's less favorable. Again, the asset forfeiture proceeding, you now know, are targeting the meritage lot as an asset. They're not targeting the claimants or the claimants as nationals. So it's an asset that's targeted. And second, the asset forfeiture proceedings were initiated and are being conducted in accordance with Colombian law, which applies equally to assets regardless of the nationality of the owner. So this is important when you determine national treatment. And again, the claimants did not receive less favorable treatment than other investors in like circumstances. This is the standard. Again, the submission by the US shows that the treatment, you look at the treatment accorded a foreign and a domestic investment or investor in like circumstances. This is also ADM versus Mexico. And here, the meritage lot has been treated similarly to other assets in the like circumstances. I refer you back to what we said earlier. And finally, any differential treatment is justified in light of the circumstances. Here, I refer you to the case law, of course, Parkrins and Pavlovsky, and we have references to why these are necessary and justified in the circumstances, and you have references to our rejoinder. We respectfully refer you back to those. Unfair treatment, 10.5. Again, next slide. You see that this U.S. submission refers, and you heard some comments about this, the reference in the U.S. submission to the fact that this Article 10.5 refers to the minimum standard of treatment under customary international law. There was issue taken by that we say that this concerns only the investment, not the investor. And the fact that the minimum standard is confirmed by the Al-Tamimi decision, which refers to the Oman-US FTA. And on my next slide, you have the US submission that confirms that Article 10.5 requires the parties to accord fair treatment and full protection of security only to covered investments, not investors. So the point made by Mr. Mulu earlier is that you have Annex 10A, which defines customary international law by reference to aliens. Again, this is neither here nor there. First of all, because Article 10.5 itself refers to investments, so you cannot rewrite the provision. And second of all, because Annex 10A says that the customary international law protect the economic rights and interests of aliens. So it's not a protection of aliens, it's a protection of their economic rights and interests. So again, it's investment, and the argument fails. So as to the facts, the respondent did treat the alleged investment fairly and equitably. And again, these are all of the standard or substandard of the FET. The proceedings were not arbitrary or reasonable. The threshold is that there has to be due process of law and juridical propriety, LC, DICJ, and Cargill. And again, we refer you back to our written submissions about why the measures were justified, reasonable, and proportional. It has to be conducted in accordance with due process of law. And what is important here is that a breach of due process only amounts to a breach of 10.5 if it results in denial of justice. And this is what you have in Aven versus Costa Rica. And this is also what you have in my next slide of what the US says. And the US says that the threshold for denial of justice is very high. And you see here in the paragraph 46 of the US submission, they say that a fortiori, domestic courts performing their ordinary function in the application of domestic law as neutral arbiters of the legal rights of litigants before them are not subject to review by international tribunals absent a denial of justice under international law. And that is a very high threshold, as the IDOM Latvia tribunal decided. And here, frankly, they have admitted on my next slide that they're not advancing a denial of justice claim in name or content. So they confirm it. And they actually rely on decisions of the courts when they're happy with them, and that's the April 22 decision that they have referred to earlier. So, and then even if it were not a standard of denial of justice, even if you were to look at due process violations, again, this is a high threshold. And the case law criteria here and AES show you that it has to be serious defects in the adjudicative process, such as violation of equal treatment, right to be heard, and core rights of litigants. And again, we refer you respectfully to our submissions about the fact that these proceedings were conducted in accordance with due process of law. Discrimination, the important point is that under Article 10.5 of the TPA, there is no prohibition of discrimination. This is confirmed by the US submission here on my next slide. So you see that just starting at the beginning, customary international minimum standard does not incorporate a prohibition on economic discrimination against aliens or a general obligation. And the threshold here again is a high one. This is SEMPRA versus Argentina. It is a fact-specific assessment, and you have to look again at like circumstances when you determine discrimination. And as we know, this they have not been treated any differently as compared to others in like circumstances. And finally, the transparency. Again, the U.S. submission confirms that the standard does not include transparency. This is also Merrill versus Canada. And in any event, again, even if there were a requirement of transparency, the threshold is very high. This is Orbesser versus Argentina. Again, for lack of time, I apologize, Rabino, I cannot go through the case law, but you have that for when you have time on your own. And finally, this time, the expectation. So the concept of legitimate expectation, again, is not included in Article 10.5. Again, this is the submission of the US. I quote, the concept of legitimate expectation is not a component of element of fair and equitable treatment. And you see at the end, again, I quote, an investor may develop its own expectations about the legal regime governing an investment, but those expectations impose no obligations on the state under the minimum standard of treatment. Again, because this is all the customary international minimum standard of treatment. But in any event, even assuming a frustration of the investor's expectation, that does not, without more, amount to a breach of the fair and equitable standard. That is the infra-capital decision, which confirmed that it's a high threshold. And only, on my next slide, only the investor's expectation that are objectively reasonable can be afforded protection under the high threshold. And this is InvestMart versus Czech Republic that confirms that this is a high objective threshold. It is not enough, I quote, that a claimant have sincerely held an expectation. The expectation must be reasonable. And also, my next slide, legitimate expectation may arise only from specific promises or commitments. This is the Crystalex decision. And the investor's expectation on my next slide must be assessed in the light of the overall conditions of the host state at the time the investment was made, including the existing legal framework. This is my introductory point. This is a very important issue. You look at Duke versus Ecuador, and you see that the tribunal there said that the assessment of the reasonableness or legitimacy must take into account all circumstances, including not only the facts surrounding the investment, but also the political, socioeconomic, cultural, and historical conditions prevailing in the host state. And again, this is including the legal framework in Colombia, in Medellin, in relation to fight and war against drug trafficking. And the investor's expectation must be assessed in light of the state's legitimate regulatory interest. This is Selucia and Miami Doyle. And as to the facts, very briefly, my next slide, the claimants could not have legitimately expected to be exempted from asset forfeiture proceedings. First, Colombia did not and could not make any specific representation or commitment that it would refrain from initiating asset forfeiture proceedings should the legal grounds for such proceedings arise. The claimants did invest in a region marred by drug trafficking activities and controlled by the Oficina de Envigado. They cannot, and they do not contest this. Their own due diligence was highly deficient. So when you enter a country in that legal framework and in those circumstances, the least you could do is to have a proper due diligence, which they didn't do. And they like to rely on responses given by the Attorney General's office, but that is not a that is not a certification of legality. It cannot create or give rise to a legitimate expectation. And finally, as Ms. Herrera Bernal emphasized, Mr. Seda was approached by Mr. Lopez Vanegas in July 2014. At the very least, at that time, he should have adopted due diligence measures and raised the issue with the authorities, and he didn't do. Very quickly, the same applies to the other projects. The respondent treated the claimant's other project fairly and equitably. Here it's important to realize that there has been a causal link between the state's conduct and the harm allegedly suffered by the investor. This is in relation to Bosch versus Ukraine. On full protection and security, again, this covers investments, as we have seen earlier. This is also the submission by the US. We also have a reference to Al-Warak versus Indonesia, which covers only investment. As you know, full protection and security offers protection against physical attacks. This is the case law that we have put here, Gold Reserve, but it's also what the US says about this treaty. The obligation to provide full protection and security does not provide for legal security, and so it has to be physical attacks. And it requires, on my next slide, and this is also reference to the case law, that the host state exercise due diligence in light of the circumstances. And so on my next slide, the Colombia did not breach its obligation to accord full protection and security. First of all, the allegations that the respondent failed to protect the claimants from an extortion scheme by the officials is wrong. The allegations fall outside the scope of the full protection and security, which only obliges, as we just mentioned, due diligence, physical security, and the investments, which is not the case here, but in any event, on the facts and the evidence shows that this is not the case. Regarding the threats or alleged threats and attacks by third parties, again, the same standards apply, due diligence, and it has to concern the investment, which is not the case. And in any event, Mr. Seda engaged in extensive negotiations with Mr. Lopez Vanegas and his lawyers, and Mr. Lopez Vanegas is a Colombian drug trafficker who has been extradited to the US. And again, you have to be careful who you deal with and not to engage in extensive negotiations with them, which he did. The Colombian authorities adopted measures to protect Mr. Seda and his family. This is, you have more details on this in the facts section that Ms. Herrera did not have full time to address. But again, given more time, we're more than happy to go through these. And finally, Mr. Seda failed to collaborate in the investigations conducted by the Colombian authorities. Again, we're more than happy to expand on this. And I hand over now to Ms. Ripko Berman.
See, time-wise, how many minutes are left? I'm afraid not many.
15 minutes.
Okay. Will you be able to deal with that within 15 minutes?
I think that should be enough.
Okay.
Thank you. I'm not sure I can speak as fast as Dr. Benifateni, but I'll do my very best
David
to
will be
be brief. So, good afternoon, members of the tribunal. I will now address some issues related to the claimant's damages claim. I will start. Yeah. Now? Better? Thank you. So I will start with a quote from Pawlowski, which contains the two elements that the claimants have the burden to prove. And these are the quantum that was actually suffered by the claimants, and second, that the damages flowed from the host state conduct, in this case Colombia, and that the causal relationship was sufficiently close. In this case, I will start with the second element, which is causation. We have seen already a bit of it, and it's not disputed by the claimants that this element is required. It's also not disputed that customary international law, under Article 31 of Articles on State Responsibility, states that the responsible state is under an obligation to make full reparation for the injury caused by the internationally wrongful act. And this is stated as well in the commentaries, where it says that this phrase is used to make clear that the subject matter of reparation is globally the injury resulting from and ascribable to the wrongful act, rather than any and all consequences flowing from an internationally wrongful act. It's also undisputed that the TPA in Article 1016(1)(a)(2) contains the requirement that damages only when they are by reason of or arising out of the state's unlawful conduct are compensable. This is explained in the submission of the United States of America, which says that any loss or damage cannot be based on an assessment of acts, events, or circumstances not attributable to the alleged breach. What does this mean? This means that damages that are too indirect, remote, or uncertain are not compensable. We have here a reference to S.D. Myers, which I will skip because we have very little time, but in BG versus Argentina, for example, the tribunal stated that damages that are too indirect, remote, and uncertain to be apprised are to be excluded, so these are not compensable. In this case, and this is not disputed, it's in fact a table containing the second expert report of BRG, the claimant's damages expert. It is clear that only 31% of the total damages claim concern. So, what do they claim? And this is when the disputed points begin. The claimant said earlier today that the construction of Luxe came to a halt because the Colpatria Bank did no longer want to finance the project after the preliminary measures were imposed on the Meritage lot. They also say that they met their prima facie burden to prove that there has been a causality here. We dispute that they have met this prima facie burden and that the burden would have shifted to the respondent, but in any case and for completeness, we would like to take you through the evidence to show what is the real cause of the alleged damages. So this first point, and you see here it's a report, a work progress report from Luxe from 29 September 2015 on slide 252. So this is a report dated 1 year before the preliminary measures were adopted. And you see that there were already significant delays in the construction. You see, for example, paragraph 5, it says that the number of staff members on site is insufficient, there are cash flow difficulties, and the project lacks the resources required to move ahead. Nothing to do with any of Colombia's measures. If we go to the next slide, you see that before the precautionary measures were adopted, the Luxe project had also experienced severe cost overruns. So this is paragraph 10 of the same report. And it says that direct cost overruns of 500 million were resulted in delays in the project, and that this value of cost overruns is expected to rise. Then if you see the next slide, and this is a statement of defense in a case before the Colombian courts, we can see that by the time that the precautionary measures were adopted against the Meritage lot, the Colpatria Bank had disbursed over 90% of the credit it had granted for the construction of the Luxe. The Luxe was far from being completed. Now, if we go to my next slide, and in any case, you've heard from the claimants of the alleged success of the project that was that of the Luxe project. Now, what the claimants did not say is that they failed to, that they did not procure financing through alternative means to finalize the Luxe project. So even if Colpatria stopped disbursing money, they could have, and if the project would have been successful, they could have obtained alternative financing to conclude the project. However, they did not even attempt to show that they tried to obtain these alternative means. And this is a quote from Dr. Hearn. This is the respondent's damages expert, that says that even if that the claimant should have been able to sell this project to another investor for a value equivalent to BRG DCF value of the project. So assuming it is true that that Colpatria Bank stopped disbursement of funds, they could have, but did not obtain financing through alternative means to complete the project. And this has nothing to do, again, with Colombia's actions. Now, the claimant's own legal representatives have also acknowledged that the damages suffered in connection with the Luxe project were caused by reasons other than Colombia's measures vis-à-vis the Meritage project. And this is a quote from Dr. Tatiana Londoño. She's the legal representative of Luxe and Seda. And she says that the delay between December 2014 approval letter and start of disbursement in January 2016 caused a cost overrun that led my client, being Luxe, to bankruptcy and to abort the construction of the Luxe project. Now, if we go to Tierra Bomba, you also heard this morning that the sellers of the land did no longer want to work with Royal Realty due to the reputational issues as a result of the preliminary measures adopted against the Meritage lot. Now, let's see what the evidence says. So the first thing you have in slide 257 is an excerpt of one of the three promise to purchase agreements signed between Mr. Seda and prospective sellers. The first thing you see is that this was a fraudulent transfer, meaning that the prospective sellers were about to sell a piece of land or lots of land over which they did not have legal title. And this is what Mr. Seda bought in Tierra Bomba, or promised to buy in Tierra Bomba, in order to develop the project. Again, if we look at the cancellation agreements, the claimant said that they were cancelled because of the preliminary measures. What we see here in slide 258 is that the contracts were terminated by mutual consent and without any dispute whatsoever upon reciprocal benefit of the parties. We also see that if we analyze further the contracts, that there were two other possible reasons which are not attributable to the respondent for these contracts to be terminated. One is that the lots by August 2017 had not been regularized, which means that the prospective sellers still did not have property of the lots. And the second one is that Mr. Seda had failed to pay the full price for the lots as per the contract. If you see, for example, Exhibit C-134, it says that by August 2017, Mr. Seda should have paid the full price. But in fact, in this termination agreement, which is of 3 August 2017, he had paid less than half of the price in other projects in Colombia. We've also seen this morning a WhatsApp message that a counsel for claimants showed. What they did not show is that in the same message that Carlos sent to Mr. Seda, he said that we would like to invite you to work with us as a consultant if we need to call upon you. This is on 13 September 2017, 1 year after the preliminary measures had been adopted, which means he was still trusted, and project managers still wanted to count with Mr. Seda as a consultant for their projects. Now, very quickly, our second point on damages is that the claimants are not entitled to compensation in connection with the alleged breach of obligations that only extend to covered investments. This, if we go, this is confirmed that by the US, the legal principle that says in the submission, paragraph 62, that for TPA obligations that only extend to covered investments, for example, minimum standard of treatment in Article 10.5, a tribunal may only award damages for violations where the covered investment incurred damages. A tribunal has no authority to award damages that a claimant allegedly incurred in their capacity as an investor for violations of obligations that only extend to covered investments. Now, if we see again, and this is the table contained in paragraph 24 of BRG's second expert report, the claimants are claiming, or 70% of the claimants' claim concern other projects that are not the Meritage. And they only claim damages in connection with this project for breaches of FET, minimum standard of treatment. So they are not entitled to these damages, and this is another reason, in addition to the lack of causation. Now, very quickly, if we go to the first element that they had to prove, which is the quantum of damages suffered, the claimant's assessment is speculative and exaggerated. First of all, the DCF method is not appropriate. The claimant's own damages expert recognized that there's 3 methods for evaluating the fair market value. In this case, they opted for the DCF, but it is not appropriate in this case because all of the projects were at early stages and they had no track record of successful operations. You can then read Deutsche Telekom, the principle is stated there among many other cases. Exceptionally, and we see that on Rosuero, DCF method may be applied to investments that are not going concern, but under very specific factors or conditions, which are not met in this case. For example, it requires a historical record of financial performance. In this case, the claimants did not have a track record of successful projects in Colombia. The only allegedly successful project, which is the Charlie Hotel, is irrelevant because it's a very different project in nature and targeted audience than the project with respect to which the claimants are claiming damages. Then there's no reliable projections or detailed plan verified by impartial experts. Unlike commodities, in the hotel and real estate businesses, there's no available market price forecast. There's also no evidence that the claimants had secured sufficient funding to develop the projects, and there's enormous risks with respect to the development of the claimant's project. Now, even if DCF method were to apply, the claimant's valuation is grossly exaggerated. Dr. Hearn has gone through the exercise of correcting BRG's assumption for DCF, even when Dr. Hearn clearly explains why DCF is not applicable, but his results of redoing the DCF method with reasonable assumptions are consistent with the historical cost approach. So we see that the claimants are claiming 199.6 million. The corrected DCF performed by Richard Hearn from NERA, it results in a range between 27 and minus 1.8, depending on certain assumptions. And the historical cost valuation results in damages of 7.6 million. You will hear from Richard Hearn on this on Friday. For the sake of time, I will pass to our last point on damages, which is moral damages. As you know, moral damages can only be awarded in exceptional circumstances, and the 2 main elements is when there's severe state conduct. For example, OI versus Venezuela refers to physical threat, illegal detention, other ill treatment, which is in contravention of the norms according to which civilized nations are expected to act. And the second element is serious damage to the physical health, grave mental suffering, or substantial loss of reputation. In this case, we have already seen that there's no such exceptional circumstances. The respondent has acted at all times in accordance with Colombian and international law. It's undisputed that Mr. Seda was not subject to physical threat, illegal detention, or other ill treatment in contravention of the norms according to which civilized nations are expected to act. And on the contrary, we have seen that the record belies the claimant's claims of harassment. I think we've seen them and they are in the slide, so I will just jump to my last slide, which is that the amount claimed for moral damages is excessive and arbitrary. It's arbitrary because it's linked to the full amount claim, which is between 23.9 and 29.6, depending on where we look at, the memorial or the reply, and whether it's only refers, or whether we look at the damages claimed only by Mr. Seda or by all the claimants. but it's also excessive. And in this table, you can see that Mr. Seda is requesting between 23.9 and 29.06 just for conduct of the state, which is ongoing asset for future proceedings against a lot on which Mr. Seda intended to develop a real estate project. Whereas in other cases, for example, in Desert Line versus Yemen, there was malicious physical duress of the executive of the claimant. There was shown impact on their physical health and on their credit and reputation. The amount awarded was only 1 million. In Von Pesselt versus Zimbabwe, there were humiliation, death threats, assault, kidnapping, etc. The amount awarded for legal damage, for moral damages, was 1 million. And then we have two cases on which Colombia, human rights cases for which Colombia was condemned to pay. One is concerns the execution of 19 adults, 1 minor, 4 children, and 17 people who were forced to move their cattle and lost their property by paramilitary groups. The amount awarded by the Inter-American Court of Human Rights was 1.25 million. And in Bedoya versus Colombia, for the failure to protect a journalist and her mother in a case involving the kidnapping, torture, and sexual abuse of the journalist, the amount awarded by the Inter-American Court of Human Rights was only $110,000. So you see that in comparison with this state conduct and with the amounts granted, the amount claimed by the claimants for moral damages is just exaggerated and even outrageous. So just to finish, the pre-award will be addressed on Friday by pre-award interest. Will be addressed on Friday by by NERA, by Dr. Hearn, and this concludes my presentation. Thank you very much. I hope I was fast enough.
Thank you.
Mr. President, if I just small clarification so that there's no this thing here. The translation on the page, I think it's 257, reads fraudulent transfer. False tradition in Colombia means when you don't have the actual title, could be a squatter that passes and registers it. So I just wanted to clarify that.
Okay, thank you. You may comment on that correction, obviously.
No comment on the correction.
Okay. Now this puts an end to the openings. Thank you very much. We now need to address the pending procedural issues. Shall we start with the new documents that the respondent intends to submit into the proceedings? Okay, let's have a comfort break of 5 minutes, yes, before we discuss that.
That's what you get for being bored.
So I was told to come closer to the microphone. All right, now the first pending procedural issue is about the documents that the respondent requests that the tribunal authorize to be submitted, and there's a list of 30 documents attached to that request. Now, we already touched upon certain type of documents, the travaux préparatoires, but we of course want to hear you first. What is your position to this request?
So, thank you, Mr. President. Very briefly, there were 4 categories of documents that were purported to rebut Mr. Seda's third witness statement, and that fell into 2 categories. Documents relating to allegations against Mr. Hernandez, which we allowed into the record, so those are, we had agreed that earlier. The second category is documents the respondent had an obligation to produce as a result of the tribunal's order from many months ago, which are just delayed productions to the claimant. I'm not sure, it's never been the case that when you produce documents to the other side, that all of a sudden just ends up in the record. In fact, if it's a delayed production of documents that they were ordered to produce several months ago, it should be our option to introduce those new documents into the record if we so wish, or some subset of them. But they wish to simply not to produce them only to us, but to enter them into the record. There's no basis, obviously, for that, so we objected to those. And again, same caveat, we have not reviewed all of those documents. The third category are documents rebutting claimant's essential security submission, and the fourth, and that includes the travaux préparatoires, which I'll deal with in a moment. And the fourth is a document that their damages expert wished to admit, which we consented to. There was one document, and that we consented to. So let me deal specifically with the documents that are alleged to rebut the essential security submission. In our submission, those are documents that Colombia should have submitted with its rejoinder. That was already late, but for example, with the travaux, you heard Ms. Benefetemi say in response to a question, well, why do we need the travaux? She said, well, this is what we always do when we interpret a treaty. We always refer to the travaux. If it's what they always do, then why was it not submitted when they initially interpreted the treaty, which was with respect to the essential security provision, which was with the rejoinder? So it's clearly late. And second of all, it's prejudicial. And the reason why it's prejudicial is because, first of all, the volume. As you heard today, there's a total of 3,000 pages. We've been given 186 of those pages, all in Spanish, so please forgive me. I cannot read in Spanish. I have no idea. I have not had an opportunity to review it. But in any event, what we received is only a subset, clearly, of minutes from the Colombian government. So it's not even what the U.S. government's minutes say. So it's 186 pages of 3,000 pages that they clearly have. It's both late. They gave it to us the Wednesday before a hearing, when they made this argument several weeks ago for the first time with respect to the essential security submission. And it's a subset that's been selected solely by them. And the volume of it, even if they gave us the full 3,000 pages, we're at the hearing. I mean, to receive, even if we were to get the full amount, 3,000 pages now is hugely prejudicial. So for that reason, we're not in a position to accept those either. Into the record.
You addressed specifically the rebuttal documents regarding...
On the second category, on the essential security, we know that they provided, if I'm not mistaken, 31 legal authorities. In rebuttal, again, we had reserved our rights. We proposed to have 19 legal authorities, total of 1,509 pages, all of which are publicly available. The only category that's not public available is the travaux. But as I mentioned, we have identified to the claimant when we shared those documents the 14 pages that discuss essential security. Now, issue is taken with the fact that these are in Spanish. Well, this is a dual language arbitration. This is English and Spanish, so they cannot take issue with us providing documents in Spanish. They're supposed to read Spanish. This is the agreement, and as a gesture of courtesy, Colombia accepted that we use English in this arbitration, otherwise it would be Spanish. And there is some point made on the damages document accepted. I mean, we have not made a fuss about it, but we also accepted there was a swap of documents. So they accepted some of ours, we accepted some of them. So I'm not even raising that. So these are on the new documents. There's the separate issue of Mr. Amarillo and some documents related to that, but I'm happy to discuss that separately.
Just a couple of brief points. The second point is the procedural order does say all exhibits must be translated into English and Spanish, so it's not me asking for that, that's in the procedural order. And the third thing, just very briefly, with respect to the case files, I don't think it's right. So I will come back to you, if I may, Mr. President, on that point, but I think, again, it's a question of selective production. On that point, though, I will come back to you, Mr. President.
One point should be clear. Whatever will be submitted, be allowed to be submitted to the file, can't be used in cross-examination or examination during this week, because these would be new documents, and it would be not appropriate, for example, to submit to Mr. Seda or vice versa to other witnesses any of those documents. Maybe let's see whether you can find common ground. We would appreciate that if you could in the evening try to come up with a joint solution as to these three categories. Let me just say that as far as the legal documents are concerned, so rebutting the essential security interest, it seems to us that there shouldn't be, they should be allowed into the record, because we said that you would have the opportunity to deal with that aspect in your post-hearing briefs in any event. As far as the travaux préparatoires are concerned, our tendency is that we would indeed like to have them part of the record, because the argument of the essential security was raised rather late. It played an important role in your oral argument, respective oral arguments, and we still need to hear the US on that, but our tendency would be to allow this to go to the record. Obviously, the whole lot, yes, because it would be difficult to ascertain whether it is correct that only 42 pages deal with the precise exception. I mean, the whole lot more in order to verify whether this is correct. I mean, there may be lots of pages that are completely irrelevant for our dispute, and I don't think that this will be such an exercise to check whether the relevant part is the one that was indicated by the respondent.
May I ask one clarification
Yes.
question, Mr. President, on that? And by the whole lot, we're talking about the full 3,000 pages, correct?
Yes.
Okay.
Yeah, but there's an index, and you can go through this. I mean, this is not,
Understood.
Sorry,
This would also mean that we reserve the possibility to have another virtual hearing on that very issue, because it is relevant, and if we now have new material on which you have to comment, which you have to review, which we have to review, we think that this could be appropriate. We just wanted to flag this. We have not yet decided this, but this would be a way to deal with that.
Understood.
Mr. President, just a clarification. The travaux préparatoires excerpts discussing essential security understand of 14 pages, and we have identified those.
I mean, Mr. President, we're in your hands, but to be getting this many documents this late in the proceedings is highly prejudicial. Obviously we've prepared a lot over the last 2.5 years for this hearing. We're now getting 3,000 pages of travel on, I don't know if we're getting them tonight or when, but this is highly irregular in my experience.
Are we then clear, or do you need to discuss among yourselves further? We said the legal exhibits are admitted, and you may comment on them in your on the post-hearing briefs. As to the travaux préparatoires, we said you may submit them, you may review them, you may comment on them in the post-hearing briefs, and if we think that we need to hear you and to discuss this exemption further, we will let you know and have a short virtual hearing on that issue.
That's understood. Mr. President, may I ask, there was obviously a negotiation about which documents to let in. These were ones that we did not agree to, but if we are going to allow certain documents, additional documents for the respondent, I would ask that at least this evening we would be allowed to just consider whether there are other documents that we might want to also admit into the record. If that
Sure.
would be
Sure.
okay.
Yeah. Fair enough. All right, then we have the second issue, namely the request that was made in relation to Mr. Amarillo. So there were two requests. One is, in our view, the same that was already decided previously, namely the financial details on the arrangement. And the second one was a bit broader, namely to explain the precise connection of Mr. Amarillo and his fund with the claimants. So, Mr. Amarillo, we allowed you to be present. We were told that you are not a party representative. So, may we take it that you are not sitting on a board of one of the claimants or of Newport, and that you are not a shareholder either? Closer.
Take the mask off.
And take the mask off for a moment.
Here.
Thank you, Mr. President. Yes, I can make this statement and representation to you that I'm not a board member with any of the claimants. Was there another sub-question?
Yes, and is your funding company shareholder, or are you shareholder in any of the companies that are among the claimants or Newport?
We are not shareholders. We provided capital in the form of debt.
And do you have security interest in shares of the claimants or of Newport?
As part of the deal that again is in the form of debt and not equity, we do have securities that we will expect that are very common in this type of financial arrangements.
Turn to the respondent. Is that satisfactory?
Thank you, Mr. President. It clarifies some things, but it's not clear exactly what the role is and the financial stake. So we continue to reserve our rights in relation to jurisdiction, in relation to tenor, until we know exactly what the situation is.
The way I understood Mr. Amarillo, though, and I may have misunderstood him, but what he seems to be saying is that he's here as a classical third-party funder?
Yes, correct.
We have explain, and that was some of the documents we wanted to put on record, and the Eco Oro precedent. So the president's question in regards to his role as a shareholder or as sitting on the board, that may not be the case now. We don't know what the case would be in the future in the event that there's an award. So we are in the dark as to the real financial interest and what type of arrangement. There's a number of different arrangements, and funding arrangements are extremely diverse. So I'm not in a position today to say I'm fine with this, because I do not know the precise stake here and who is the real party in interest financially.
With respect, you're not more in the dark than any respondent in a third-party financed case, are you?
And it's not because in other cases it's been kept in the dark that it's more appropriate. I think that it's quite appropriate, and this tribunal should know, and we're entitled to know what are the financial stakes and who's the real interested party financially. This is our position.
That's a good question.
Yes, sir.
Has there been any change in the relationship, the original relationship, as a funder, as a third-party funder, since the issue first came up at the outset of the proceeding until today? So has the funding agreement changed in any way from what we discussed and decided initially at the outset of the case? Has there been any change?
No. I think there's been, I guess, to answer your question, there's been additional funding that's been required because of all of the various applications, etc. And I hope there will not be any additional funding in light of the documents we're about to receive. But that's it. The underlying relationships have all remained the same since the initial request was made.
Sorry, we do not have to decide this tonight, but we have on the record now your declarations, and we will consider whether we think that they are sufficient. And you also said that you wanted to reflect on this. So for the time being, the issue is still pending. We will decide on it, but not tonight.
That's understood, Mr. President. I just would like to put something on the record, which is I do take issue with the fact that there's somehow issue taking with the fact that we somehow create procedural incidents. This case is a case where extremely serious allegations of corruption have been made against the Fiscalia, the entirety of the Fiscalia in Colombia. We take issue with that. This is a case where these allegations are made in the context of war on drug by Colombia in relation to Oficina. This is not this minor matter. So we're the ones having to constantly respond to procedural incidents. So I take issue with the fact that somehow, in this very serious context, we're the ones creating apparently procedural incidents. We're not. We're trying to respond. And an example is Mr. Seda, the discussion. I understand the tribunal's decision, and I respect that. But Mr. Seda provided a third witness statement on 25 April. We reserved our right to put documents on the record that rebut the allegations made in there. We just have been denied that right. They're being given the right to make other responsive documents, but it has to go both ways. And those allegations are, we simply, the documents that we sought to put on record were responding to Mr. Seda's allegation that he cannot comment because these are not transcripts. So you want transcript? We're happy to give transcript. We have nothing to hide. That's what we're saying. We're happy even to give the audio recordings. We're happy to give them the synopsis and say, these are the relevant ones, but you can check. So this is a question of transparency, and we've been as transparent as we can. And by the way, this has been taking a lot of resources within ANGE, who has a lot of more important matters to attend to. So I do take issue with the criticism.
You don't take issue, do you, with the fact that Mr. Seda is on tomorrow, right? So you shouldn't, you will agree, won't you, that he shouldn't be confronted with documents that would arrive on the record tonight?
Dr. Ponce, we provided this days ago. Had they accepted, because that's their criticism, they're saying they're serious about this, they can say, yes, we look at them, and then we would not be here today discussing about what's going to happen tomorrow. So this was provided as soon as we could, because we received on 25 April the third witness statements with some allegations there. So we have to, and we reserved our right to respond to that. So we did our very best within the time that we had with extremely limited resources to respond to that and to rebut it. Had they said yes a few days ago, they would have had that a few days ago. Now, I understand the tribunal has made the decision, fine. So we will proceed as the tribunal has decided. But I am taking issue on the record about what criticism is made of us.
Okay, that is on the record. Do you want to react? I mean, we know that this is a very serious case and that it involves serious public considerations, but also private investment considerations. So, so far you have very professionally dealt with this difficult case, and we would appreciate if you could continue in this fashion. But you may, of course, react to what was just said.
Professor Sachs, I think you know probably what I would say, so I don't think it is necessary to belabor that point.
Thank you. So, this is the end of today's hearing. It's been a long day. Thank you, David, and thank you all. We will continue tomorrow at 9:30 with the examination of you, Mr. Seda. So we wish you a nice evening and see you tomorrow. Oh, I'm sorry, yes, because where's the gentleman representing the US? Is this,
He left.
he left.
Exhaustion.
After 5 p.m.